I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13 Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Bill Barber, you should reach for it. And then I just looked at the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, come pop in and say, hey, watch.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello. That little clip of Lucy at the end on the beach is my favorite thing in the world. Hello. Can y'all hear me? I've been having audio issues in the mornings the last few days, so we'll see how it goes. I'm a few minutes late. I was listening to closing arguments in Harmony Montgomery. I haven't been able to watch much of that trial because actually I haven't really watched any of it because it's heartbreaking. And I have to be in a certain mental space to be able to handle stuff with kids, and I am not in that mental space right now, so I have not really been watching it. But I did want to hear some of the closing, so I was listening to some of that. So I'm running a couple minutes late, but we have a big day today. Oh, look, I put that chapstick on and it makes my lips shiny because the light coming in makes my lips shiny. We have a big day today. Today is the day that the state rests their case. Finally. I've been cheating. I've been looking a little bit at some of the stuff that's going on today and some of the stuff from the reporter that's in the courtroom. So I have cheated a little bit on y'all this morning just to see some of the stuff that's going on. And I'll update you as we go through, as we catch up, because we're not too far behind them. But as we catch up, I will update y'all on some of the stuff. We'll catch up by the end of the day. So this is day 25. Day 25. Oh, day 25. This has been the longest trial ever, right? And I will tell you that they updated the schedule a little bit. So I know that I mentioned yesterday when they were talking about it that we're not going to have the contempt hearing during verdict watch, which would have been easy for us, but they're going to do it before, so that's fine. We'll get to see it beforehand. So I think they're planning on, the defense plans on being done on Monday, and then they're going to do the charge conference after that, and then they're going to do the contempt hearing. So we should have the contempt hearing on Monday. Now I'm gonna be honest. Obviously, I'm still going to be in treatment next week, so I'll be starting later again. But when I get home, it'll probably be, they won't have started the contempt hearing. I don't care what they're doing at the time that the contempt hearing starts. We're going to watch that part live. We can watch the charge conference and all that later, but we're going to watch that contempt hearing live because I don't want to miss that. That'll be interesting. Fireworks, y'all, fireworks. So today, they started this morning, outside the presence of the jury. There was a motion filed, for one of the defense witnesses. So that's what we're going to start with. So let me get pulled up. Here we go. Anticlimactic. I'm like, here we go. And there's nothing there. Okay, hold on, wait. Let me see if we... All right, here we go. Here we go. Here we go. Y'all don't have sound? I have sound. Hold on. What'd I tell you? All these.
As you mentioned, I filed a motion with the court yesterday on behalf. Yes, Madam Clerk. Patrick Jennings from the Mental Law Group on behalf of Attorney Mike Rose. And Your Honor, thank you for setting this in and hearing this motion. The motion was filed on behalf of Attorney Mike Rose, who represented Fotis Dulos in a divorce proceeding. Defense counsel has subpoenaed Attorney Rose to testify in this matter, and it is our position that the content of his communications and interactions with Mr. Dulos are
Okay, I'm making sure y'all can hear it now because everything's on a delay. So when I do something, I have to wait like 10 seconds for y'all to let me know that you can hear it. Thank you, Robert McNamara, for the super sticker. Thank you.
Barely fall within the protection of the attorney-client privilege. That privilege, as the court is well aware, has long been recognized in the state of Connecticut and across the country. It is of paramount importance to the legal profession, and case law is also clear that that privilege survives the death of a client. There are very limited exceptions to that privilege. One such exception is the crime fraud exception. And in those instances where the facts fit squarely within an exception to the broad privilege, a court may rule that it does not apply and compel the testimony of an attorney. In order for that to happen, the court must find that probable cause exists, that the content of the privileged communication, or the content of the communication between the attorney and the deceased client involved the planning or commission of a crime. Essentially, that the client used the services of an attorney and the attorney served as a conspirator in the committing of a crime, either knowing or unknowing, but used their professional services to aid and assist the former client in the commission of a crime. It's our position that those facts do not exist here. The representation at issue concerned a divorce proceeding, fits squarely within the bounds of that privilege, and as such, Attorney Rose cannot and should not be compelled to testify. Furthermore, that divorce proceeding was sealed by the divorce court in that matter, which poses a further limitation to Attorney Rose being able to comply with a court subpoena and provide testimony in this matter.
Okay, so this is the attorney for the divorce attorney Rose, who they mentioned yesterday is they're wanting him to come testify. Defense has subpoenaed the attorney Rose, I can't remember his first name, whatever it was. They subpoenaed him to come testify about stuff that he knew with Fotis about his reactions to things or whatever. So I was about to say Commonwealth. I'm getting all my trials mixed up. So the state is saying they do not, or the state doesn't want him to do it. They said it falls under attorney-client privilege. This is the attorney representing the divorce attorney. So he's saying that the same thing. Like he's saying, like they want to quash the subpoena, that he should not have to testify because what Fotis talked to him about or anything that was going on with that, with the divorce proceedings that were sealed, like any of the stuff that was going on with that is attorney-client privilege, and he doesn't have to testify it. The only exception he's saying to that is if the attorney had been involved somehow in the commission of these crimes, which that's obviously not what happened. It was the divorce attorney. So he said that he should not have to testify. So that's what this is about.
Reasons we're asking that this honorable court quash the subpoena.
Attorney Schoenhorn, you may be heard.
Thank you. And I thank Attorney Jennings for this presentation. I did speak 2 days ago with Attorney Ment regarding this matter, and with his permission, I also spoke with Attorney Rose. I don't disagree with much of what Mr. Jennings just said. He is a little bit incorrect when he states that the privilege applies not just to communications, but to any interactions. That's simply not the case. I note that under the Code of Evidence 5-1, specifically, and under Connecticut case law, the only communications that are covered by the privilege are those that protect some information regarding informed legal advice, quote unquote. And that's, of course, from the seminal case of Tom Ullman versus State. I know Your Honor was familiar with the late attorney Ullman. I don't know if Your Honor was aware of the circumstances, but the court had ordered that he testify against his client concerning communications of when the case was on. I can't remember if it was a failure to appear case, but were certain information that was conveyed that was ordered disclosed because it did not fall within the meaning of the attorney-client privilege. It specifically under that case and some of the other cases cited has to be inextricably linked to giving of legal advice. So, for example, giving a client telephone numbers, et cetera, is not covered by the privilege, as well as if it doesn't go into the substance of the representation, it is not covered under cases such as State versus Davis. The code is, of course, talks about back and forth. So it's reciprocal communications between the defendant and his lawyer and vice versa. And the purpose is to encourage frank disclosure by client to lawyer without the fear of subsequent disclosure. And I agree that the fact that the individual, in this case, Mr. Dulos, is deceased does not in any way waive the privilege any more than a psychiatric privilege is waived by the death of the patient in that case. So I'm not sure what the extent is of the concern regarding the testimony. Attorney Rose is not testifying today. He's not scheduled to testify today. And he's going to only be testifying the events time-wise surrounding the production and the review of certain documents, particularly the Dr. Herman report by Mr. Dulos and Mr. Rose. Without getting into their communications, Your Honor, recall that Attorney Meehan was called by the state, and he was allowed to testify to certain reactions, certain comments made in his presence with Mr. Rose present. So I'm just going to indicate that to the extent that that matter is going to be covered, it's no further. It's the same limitations as was presented with Attorney Meehan and his testimony. I also want to correct one statement. I'm not sure that Attorney Jennings was aware. The family court matter, the only thing that was sealed was the 2 court appearances on May 14th and May 17th, 2019, and the transcript and the discussion of what happened there, as well as the sealing of the report, Dr. Herman's report. Everything else remains, well, unless it's been destroyed by now, but remain in the public record. I was able to get a complete copy of documents from the court clerk's office of every pleading going back. Other transcripts were available, had been prepared and disseminated. So I'm aware of the court's restrictions. I had no intention of going to that. I have no intention of going into any of the substance of communications between Attorney Rose and Mr. Dulos. And of course, that would not cover communications that Mr. Rose had with my client, which I intend to elicit to a small degree. There were communications with my client directly by Attorney Rose. So I think that based on that, that should eliminate any concern raised by Mr. Jennings. And I would note when I presented what I intended to get into with Mr. Ment, he also agreed with me that he did not see that that would fall within the purview, but to be safe, he wanted to make sure that the court understood that the privilege was still in effect. And I fully, not only do I accept that, I fully agree with that as an important concept.
Thank you. The court is not inclined to grant the motion to quash. What the court will require, though, Attorney Jennings, you may approach the podium. The motion requests that this court issue an order quashing the defendant's subpoena or otherwise limiting the scope of any compelled testimony through an appropriately tailored protective order. The court would require a protective order drafted by your office to be considered. It is not the court's role to draft its own protective order on behalf of any party. So if that can be filed today, the court will take that up probably tomorrow. The court does not know when Attorney Rose is scheduled to testify, but the court will consider taking up a protective order, which the court may grant, deny, or modify. And that should be filed by the close of business today.
Yes, Your Honor, and I will speak with defense counsel. I know my partner, Mr. Ment, already has, and try to tailor any protective order to the content that counsel seeks to elicit from Mr. Rose.
Thank you.
Thank you, sir.
We are still 10 minutes ahead of schedule, so we'll take our 10-minute break until 10 o'clock, and then we'll start the proceeding. Thank you.
All rise.
All right, so they're going to, he's going to allow him to write out like a protective order outlining provisions of what's allowed in and what's not allowed in from the attorneys. Obviously, they're going to, the stuff that is protected, they're not going to allow in, so they'll have to.
Would counsel stipulate, please?
Yes, Your Honor.
Yes.
Thank you. Ladies and gentlemen, we continue with the state case.
Yes, Your Honor. The state would call Gloria Farber to the stand, please.
Oh, man. Okay, here comes Jennifer's mom. This is sad. When Jennifer's mom came in, all 5 of Jennifer's kids came with her and were in the courtroom. So sad. Oh, I'm already sad. I'm already heartbroken.
Mrs. Farber, if you wouldn't mind taking a look at the clerk. Thank you.
Right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I solemnly swear to tell the truth, the whole truth, and nothing but the truth. This is so help me God.
Thank you. If you could state your name and then spell it for the record.
Gloria Farber.
And spell it.
Pardon?
You could spell your name.
Gloria, as Frank, Arber.
Thank you.
Ms. Farber, you may be seated.
I'm already sad. Oh, God bless her.
Good morning, Mrs. Farber. How are you?
Good morning. Fine, thank you.
Mrs. Farber, may I call you Gloria?
Yes, please.
Okay, thank you. Gloria, how are you related to Jennifer Farber?
She was my daughter.
How old are you, Gloria, if you don't mind my asking?
88.
Okay. And where do you live?
I live in New York City.
When was your daughter's Jennifer Farber?
Yes.
Okay, when was Jennifer born?
She was born September 27th, 1968.
How many children did Jennifer have?
5.
And what are their names?
Petros, Theodore, Christian, Constantine, and Noel.
How old was Jennifer in May of 2019?
50.
Now, in the time before May 24th, 2019, did you see your daughter often?
Yes.
Did you speak to her often?
Yes.
Did you see your grandchildren often?
Yes.
Now, on May 24th of 2019, did you have plans to see Jennifer?
Yes, I did.
What were those plans?
Well, she was going to meet us at my apartment.
Is that in the city?
In the city, in New York City.
And were the children coming as well?
Yes, they were.
And did the children show up at your apartment that day?
Yes, they did.
Who brought them?
Lauren Almeida.
Lauren's the
Now,
nanny.
was Jennifer supposed to come to your apartment to meet you and the children there?
Yes.
Did Jennifer show up at your apartment that day?
No.
Have you seen your daughter Jennifer since she failed to meet you at your apartment in New York City on May 24th, 2019?
No.
Have you spoken to her on the phone since that
No,
day?
I have not.
Have you gotten any emails or text messages or any communication from your daughter since that
No.
day? I'm sorry, you have to speak up. Quick.
No.
Okay, thank you. And Jennifer's 5 children, when was the oldest one born?
April 20th, 2006 by 4 minutes, because they're twins. So the oldest one is Petros. So there was 4 minutes apart between Petros and Theodore.
So the oldest by 4 minutes?
Yes.
Okay. In 2006?
Yes.
Between 2006 and 2019, did Jennifer ever miss one of her children's birthdays?
Never.
And the children celebrate their name days, right, under the Greek culture?
Yes, they did.
Did Jennifer ever miss a name day between 2006 and 2019?
Yes.
Was she always there for them?
Pardon?
Was Jennifer always there for them?
Yes, she was always there.
And as of now, 2024, do you have custody of the 5 children?
I do.
And since May 24th, 2019, have any of the children ever seen or spoken to their mother?
No.
I have nothing further. Thank you.
You're welcome.
Good morning, Mrs. Barber.
Good morning.
Oh,
I just have a few questions for you, if I may. Can you hear me okay?
no.
I do.
Was Jennifer's plan to come to New York by herself or with the children?
By herself, because she dropped the children off at the New Canaan Country Day School.
And the children did come with Lauren to New York that day to
Yes.
your apartment?
Yes.
Were they there at about 12 or 1 in the afternoon?
I'd say about 12 or 1, yes.
Did you reach out by telephone to Jennifer the day before she came to New York?
Objection.
Brown.
Outside the scope, Your Honor.
It is outside of the scope.
Well, it's a preliminary to the plans of her coming to New York, Your Honor.
Well, the objection is sustained, but you can continue with the line of questioning.
Did you make plans with Jennifer to have her come to New York the next day? Did she share that with you?
Yes, she did.
Did she mention she was first going to a doctor's appointment that morning?
Objection, Your Honor.
Well, the court allowed the question concerning plans, and so this is a follow-up on plans. Overruled.
You remember the question, ma'am?
Did she have plans to visit a doctor?
Before she came to your apartment?
Yes.
Do you remember if it was a Dr. Geronimus that she was going to see that morning?
Yes.
And did you, as part of your making plans with her, did you try to call her the day before to confirm those plans in the afternoon?
Objection, Your Honor.
Well, now the line of questioning goes from what was the plan to did you try to confirm the plans? And so the court is going to sustain the objection.
I'm getting annoyed.
Did you speak at all to Jennifer that morning of the 24th?
No.
Did you call her on her cell phone?
No.
Objection, Your Honor.
Well, the answer to the question was, did you speak to Jennifer that morning? The answer was no. The court understands the second question to be, did you attempt to contact her that morning? You may ask the question again, Counsel.
Did you attempt to contact her that morning?
No.
Did you have her phone number at the time?
Of course.
Do you recall what that number is today?
Objection, Your Honor.
Sustained.
I have no further questions.
I have nothing further. Thank you.
Ms. Barber, you may step down.
Thank you. Thank you.
Bless her heart. Messy Mistress didn't even look up. Him saying, did you try to contact her? I'm wondering if he's...
State rest, Your Honor.
So, ladies and gentlemen, what that means is the state at this time rests its case. The state, if the defense puts on witnesses, the state has an opportunity, if it so chooses, to present rebuttal witnesses. But as of right now, the state rests its case. The court has to take up at this point legal arguments. And if the defense has witnesses ready to be called after those legal arguments, we will resume the session. So please do not discuss the case. And we probably are going to be in a much longer recess than normal. Are there defense witnesses ready for today, Attorney General?
Yes, Your Honor.
Are they ready this morning?
We were informed that they would arrive by 11. We didn't know how long the state's case would take.
Thank you. So we'll stand in our recess, ladies and gentlemen, until 11 o'clock.
Peter, happy anniversary, 9 whole months. Happy anniversary. Happy anniversary.
That motion was filed yesterday, February 20th.
Yes, and I'll note that originally we thought the state would complete yesterday. So even though it's dated yesterday, it's to take effect at this point now that the state is rested.
Thank you.
I move for the court to grant the judgment of acquittal on each of the present charges, each count separately, and I will just go through each of them. The state has presented, and again, the standard for motion for judgment of acquittal, is there any evidence that the jury could find beyond a reasonable doubt that the state has met its burden on each and every element of the offense charge?
Okay, so real quick, this is, I'm going to pin it, what we're doing. Not that people read it, people will still ask, but it's going to be up there anyway. So the state has rested. So now Shoehorn's going to get up here and yap about how there's no evidence and that he's going to ask for a judgment of acquittal, like a motion for acquittal. This is common. It happens every single case. They always ask. It's very, very rarely granted, but they always try. So he is now going to get up and present his case to the judge about why he thinks that instead of having to present a case to the jury, that the judge should just go ahead and acquit her and let her go.
This is where I will concede that there is sufficient evidence of certain elements that would have to be resolved by the jury. So, for example, I believe the state has been able to show that a jury could find that Jennifer Dulos is deceased. We would also concede, for purposes of this motion, that the death of Miss Farber Dulos was either induced by or...
Okay. He's already giving me a headache. He's saying that he concedes that there is enough evidence for the jury to find that Jennifer is dead. Yet for 25 days now, he's been, arguing the fact that we don't know that she's dead. But now outside the presence of the jury, he's like, yeah, they got enough to know that.
Or caused by Fotis Dulos, either directly or indirectly. What I submit that the state has failed to establish is whether that death was caused by the specific, under the common law, we call malice aforethought, which means intentional killing of another individual under the statute providing for the elements of murder. That, however, even if the state could do that, even if the state can argue that there's sufficient evidence to show that Fotis Dulos planned the outcome that occurred, we have to also remember, Your Honor, that much of the state's evidence is based on this presumptive testing, which I note under State versus Moody, in and of itself fails to provide any evidentiary value whatsoever. So even though the jury and the court hasn't yet fully instructed the jury, the court made some comment to the jury about what it's allowed for. But luminol and Castle-Meyer are not evidence of blood. So the fact that there's been a lot of testimony about that, it's in the interrogation videos, it was the subject of many witnesses' testimony, it does not provide any basis for the court or for any fact finder to determine that that was in fact blood. And for reasons that we still don't know, there are only three items that were tested, and we concede one of them being the shirt and the other being the bra. And I forget what the third one is right now, but it was one other place where they did test, and it was determined to actually be not just a blood-like substance or something that tested under a presumptive test, but was in fact blood. The problem with the state's theory of this case, and as it was presented, is that the state spent a month or more trying to prove that Fotis Dulos killed his wife. None of that, however, none of that evidence pointed to Ms. Troconis as being a party to that plan, that design, or the acts involving the death itself, or the cover-up afterwards.
Okay, so this is one of the most important arguments, not for him. The judge ain't going to grant this. It would shock the bejesus out of me if he did. But not for this argument in particular, but when the jury goes to deliberate, this is one of the most important arguments is the way that the evidence was presented is, did they prove that Michelle is a knowing participant in the acts of what happened to lead to Jennifer's death?
I would readily concede that the court proved that Fotis Dulos was involved in the covering up of a crime, whether that crime was murder.
I have it at 1.25. Do you want to, you're asking to speed it up. I can try 1.5. If this is too fast, y'all let me know.
As the state alleges, or some other crime. Again, the way it's been charged, that it could only be murder. It cannot be manslaughter. It cannot be a reckless death during a fight or a struggle. It has to be murder because that's the way the state charged this offense under count 1. In fact, the way they charged it is they say that Fotis Dulos, quote, did assault Jennifer Farber Dulos in her home on the 24th day of May, 2019, with the intent to restrain and kill her in violation of sections 53A, 48A, and 53A-54A, subsection A. I will note there has been no evidence from any source of any restraint, but let's just assume that there's still enough to at least allege that there was an intent to kill, even if I submit the evidence doesn't support that. But now we get to the question in count 1 of conspiracy. Under our law, under Connecticut General Statute 48A, the state must demonstrate essentially 4 things. One being the underlying purpose being to restrain and kill Jennifer Dulos. The first question is they have to prove that Michelle Troconis intended to commit that crime, the specific crime of murder. 2, that there was an agreement between Michelle Troconis and Fotis Dulos to commit that crime of murder. 3, that the specific intent was to restrain and or kill, not or, Jennifer Dulos. And 4, if there was an actual agreement to do those things together. Now, the state has alleged that the defendant agreed with other persons, quote unquote, to engage in these crimes. The state is not required to actually place in their information who those other people were. We've heard the names of possible other individuals. There was Kent Mawini. There was Andreas Koutsiardis. There was even Pavel Gumieni as people that may have committed acts that might be considered certainly suspicious, but the state made no effort to demonstrate that Michelle Troconis agreed with any of them to commit an offense.
He tried to throw Pavel in there again.
I now want to just talk about the count. Basically, I'm going to not repeat what I'm saying about the crime of conspiracy, other than conspiracy is a specific intent crime. Not only do you have to prove the underlying elements that the defendant was involved in, but that she had a specific intent to agree to commit those offenses in advance. And if one looks at and I'll start with count 2. Count 2 specifically alleges that Michelle Troconis entered into a conspiracy on 24th of May, 2019, in the area of Albany Avenue in Hartford, to commit the crime of tampering with physical evidence with the intent that conduct constituting that crime be performed, and did agree with Fotis Dulos to engage in and cause the performance of that conduct. And one of them, I would submit the only other one, is Fotis Dulos, did commit an overt act in furtherance of the conspiracy. It goes on to say that Michelle Troconis traveled with Fotis Dulos to the Hartford area for the purpose of disposal of physical evidence relating to the murder of Jennifer Farber Dulos in Hartford on May 24th, 2019. That's the allegation that's been submitted. I submit there is no knowledge, no evidence whatsoever that Michelle Troconis either agreed to do that or had any idea what was going on, what Mr. Dulos was doing. We've spent, I don't know how many hours of interrogation video. She never, so we start with the fact she said absolutely nothing that would constitute admission to any knowledge of that. To the contrary, she repeatedly, over the course of months, denied any knowledge as to what Dulos was up to. So what is the evidence with regard to that? We do know, let's work backwards, the police did not come to the home of Dulos and Mr. Troconis until approximately 8:30 the night of May 24th, 2019. The testimony is they came to the house and told Mr. Dulos, and my client heard part of this, that Jennifer Dulos was missing. This, of course, is after they were in Hartford on Albany Avenue. So we have black garbage bags, opaque garbage bags. We see Mr. Dulos placing them in various receptacles. Only one of them, incidentally, contained any items of evidentiary value to this case. The ones where the 2 garbage bags, the shirt, the bra, a number of other items that were found with blood on them. They weren't in garbage bags. It was spread among whatever trash was in that barrel. But be that as it may, the evidence is uncontested that it was Fotis Dulos who got out, took the garbage, and threw them in those barrels. This is prior to any time that Michelle Troconis would even know that there was a crime that may have occurred and that there was an investigation that was beginning. So in order to be guilty of tampering with physical evidence, it specifically requires, under the statute, that believe under 53A-155 that the defendant would have to believe that a criminal investigation conducted by law enforcement or is pending or about to be instituted. And it claims that she either destroyed, concealed, or removed anything for the purpose of impairing its ability to be used in the criminal investigation. Again, the only evidence is that she only even learned that there was an investigation afterwards at 8:30 at night, after they had been to Albany Avenue, after they'd been to Starbucks, and then they went home. So I submit that there is zero evidence in the record to allow any reasonable trier of fact, to conclude.
So he's saying that because police had not come to tell them yet that Jennifer was missing, that all of that evidence disposal is not like she would not have known that that was considered evidence yet, because he's saying that she didn't know what happened or what was going on. So because she hadn't been told yet that there was even a problem or that Jennifer was missing or anything like that, since she hadn't been told that yet, that there would be no reason for them to be able to charge her with that.
Conclude that she engaged in that conduct or agreed in advance to that conduct, either substantively or in a conspiracy to commit that crime, in the absence of any evidence that she knew there was a criminal investigation at all, or that even one was being instituted. If I may move on. I will also note, Your Honor, that there's a lot of cases that specifically say that mere presence or even acquiescence in the conduct of someone else is not evidence of a crime. And a jury has to be instructed that that cannot be used as the basis. There has to actually be affirmative evidence. Merely being present under our law is not a basis to convict anyone of any crime, even if they're sitting there while someone else is engaged in obvious activity in their presence. Count 3 is the substantive offense of tampering with physical evidence, again, under 53A1, 55A1. It is charged as accessory under 53A-8. I note that under our law, the crime of accessory and the principal crime are the same. They are two manners of committing the same crime. But the way it's been charged here, it indicates that simply that she committed the substantive crime. I guess there's zero evidence that she did that. She didn't touch anything that's connected to a crime in the city of Hartford on May 24th, 2019. I will note, Your Honor, I'm anticipating what the state's going to say. Well, there were 3 cells of partial DNA of Mr. Troconis found on the exterior of the opening of the bag. So the place where you would hold it, you grab a bag, might pull it out of a box, but it was partial, and the state did not test either Mr. Troconis' mother or her daughter, who also lived in the home, even if they can assume that these garbage bags came from that box of trash bags that was seized from the home itself. There's an interesting recent Connecticut Supreme Court case on this that Your Honor should be at least aware of that I want to cite. Say versus Dawson at 340 Connecticut, 136, 2021. That is a case where there was a firearm discovered where there were in the immediate vicinity of 3 or 4 individuals. And the Supreme Court in that case ruled in 2021 that DNA evidence standing alone does not establish that the defendant had dominion or control over that weapon. So they reversed the conviction, saying the presence of DNA, and they went into this issue of partial DNA, the number of picograms, the idea of transfer DNA. They say that is not enough to convict anybody. And I submit that that is precisely where we're going with this particular case here.
That's misrepresentation.
That 3 cells that are a partial match to Mr. Troconis cannot be the basis for such a finding with regard to that charge. Now let's move on.
Okay, that's kind of a misrepresentation. If you're like the case he's talking about, like, okay, like if your DNA is on a gun, okay, that itself is not enough to convict. No, because if there's an explanation for stuff being anywhere or whatever, that's not enough. But it's puzzle pieces, as our BFF Rashi would say. Like, there's a lot more to it than just that one thing. So he's kind of making an argument that's, based on him misrepresenting case law, which is shocking since he misrepresents everything he says.
4, 5, and 6, which all relate to the Russell Speeder car wash in Avon, which is where the state alleges. So we're talking about what happened on Mountain Spring Road. That is not the charge. The fact that Mr. Dulos handed Mr. Troconis a paper towel that did not smell like anything that she put in a garbage bag is not what they're charging here. It's according to the way this case was charged. It says that she both tampered with and hindered the prosecution by, did agree with Fotis Dulos by transporting transporting the 2001 Toyota Tacoma used in the commission of the murder of Jennifer Fotis Dulos to Russell Speeder's car wash for the purpose of having evidence relating to that murder concealed and destroyed. The count 5, tampering, specifically indicates that believing that the criminal investigation was pending or about to be instituted, altered, destroyed, concealed, or removed a thing with the purpose of impairing its availability in the criminal investigation. And finally, under hindering, did render criminal assistance, as that is defined, to another person that she believed committed a murder. I mean, it specifically committed a Class A felony, to wit, murder, did provide Fotis Dulos with transportation and other means of avoiding discovery and apprehension. Well, even that is baseless here, Your Honor, because she did not provide transportation to Mr. Dulos to bring the vehicle there. The only testimony is that she followed outside in a separate vehicle, I guess on May 29th, which is what the allegations are here, and then picked him up at the car wash. The only reasonable interpretation is she was somewhere outside, not even visible. He had to call her on the phone to come get him. And of course, this is after the vehicle has been brought in. And then the testimony is they then together drove down to Attorney Bowman's office in Westport. And then when he came back, we had the video. Mr. Dulos obtained some cash and went inside and paid for the detailing after it was done. There is no evidence that Mr. Troconis had anything to do with that. There's no evidence that she had any involvement in that bank account, that she even would have known what he was taking out and for what purpose. He went in alone to have the car detailed and washed. He alone went in to have it, to pay for it after the fact. And I just want to also clarify because, it took a little.
Okay, so he's saying like all of this stuff about like her going and following Fotis to take the Tacoma to the car wash and all of that. That doesn't prove that she hindered an investigation because she wouldn't know that she didn't have anything to do with it and doesn't know that, what they were doing. And, she just thought that they were going to clean the car. What did she say? That she thought they were going to drop it off to be detailed because Pavel wanted to sell it. So he's saying that, her actions that they're saying are evidence are not actually evidence of this because she didn't know anything about it, that, it was all Fotis. It's funny, this whole time he's been like, oh, you don't know that Fotis's DNA could have been on that faucet because, of chocolate Easter bunnies. But now it's like Fotis did it. Fotis did it all.
We got Detective Cloudy yesterday to admit it. I'm sorry, Detective Kimball to admit it. But even Mr. Dulos did not falsely give information about the Toyota Tacoma to the aide. That in fact, the employee had mistakenly written the phone number on the line of a vehicle that came at 8:44 in the morning, and then rewrote it on the line below where it didn't indicate the name of the person who was bringing in that vehicle. So I don't need to repeat. For each of the crimes, you have the same elements. For hindering, all requires specific intent. They have to specifically show that the purpose was to commit specifically a crime, a Class A or B felony, that you had to be aware of that. In this case, it had to be by the way that the case was charged. Murder, not any other crime. Not any other crime. There's just one other, and when I refer to the log sheet, Your Honor, I'm referring to State's Exhibit 138, the Russell Speeder log that was introduced, in which I showed as well to Mr. Kimball yesterday. So just want to have a moment. I know that, and I'm just going to say this for the record, I know that Judge Lowy denied this, but I want to incorporate my arguments about vicinage and venue for my judgment of acquittal in the case that vicinage is a requirement of the location of the crime. And that all of these crimes, all of them, including the conspiracy, all occurred in the Hartford Judicial District. I stated for the record, I'm not asking the court, well, I would ask the court, I don't want the record to suggest I waived the issue. So I raise it now so that the court is aware that I'm making that also part of my judgment of acquittal argument at this time. Let me just look at my notes for a moment, Your Honor.
He asked to have the trial
when
moved.
I made the comment about mere presence as an inactive companion, passive acquiescence, or the doing of innocent acts which may in fact aid the one who commits the crime must be distinguished from the criminal intent and community of unlawful purpose shared by one who knowingly and willfully assists the perpetrator of the offense in the acts which prepare for, facilitate, or consummate it. That's from State versus Enano, which goes back to 96 Connecticut 420. It's also cited in State versus Pundy, Pundy at 147 Connecticut 7, where the court went on to say that those who simply are companions in passive acquiescence may be said to be innocent of any wrongdoing. Just want to check my notes one more time. I'm just going to mention, in case the state, instead of standing up a second time, I'm going to just mention Pinkerton liability in case that's one of the state's arguments. That doesn't apply here. And I will note that under Pinkerton, such cases as State versus Bennett at 307 Connecticut 758, which cites to the Pinkerton decision at 328 US 640, require a community of criminal intent and community of unlawful purpose with the perpetrator of the crime, and must be knowingly and willfully done to assist the perpetrator in the acts which prepare for, facilitate, or consummate it. Under those cases, Your Honor, and there's numerous cases that now deal with the Pinkerton liability, that applies when if somebody is going to rob a bank and they conspire in advance to rob the bank, and there's evidence of that conspiracy, but one of the co-conspirators pulls out a gun and either shoots someone or at least threatens the gun. Co-conspirator can say, well, I didn't know he had a weapon. But under Pinkerton liability, if it's within the furtherance and it can be believed to be a likely alternative or outcome, that could happen if you're going to rob a bank, there's an inference that it may be probable somebody may be armed. You can be held liable to the more, what's the best way to put this, to the enhanced penalties or the aggravating factor that would be contemplated within the crime accused. But you have to go back to knowing what was happening in the first place. If you go to the bank, for example, to make a deposit and the person you're with robs the bank, pulls out a gun and robs the bank, if there's no evidence of an agreement, you're there just to make a deposit, that could not then subject the person to Pinkerton liability merely because he or she was present. In other words, it doesn't shift that liability and do away with the requirement of concert and concerted effort and agreement to commit the crime.
Well, the touchstone of Pinkerton is foreseeability, correct?
I'm sorry, Your Honor?
The touchstone of Pinkerton is foreseeability.
Foreseeability, that's right.
God, this judge is on
And of course, and I also, when I read Pinkerton, it's not only just foreseeability that one of the people will do something else, but you are already committing a crime. It is not foreseeable that if you go into the bank, a friend of yours may commit a robbery. It's that you agreed in advance. It's just that it's foreseeable that maybe that other person that you already agreed to commit the crime with did something more egregious than simply ask for money and hand up a note. So that's the claim that I'm making with regard to that. There was just one other point, Your Honor, that I wanted to make before I sit down.
His whole thing is that
there are a couple other cases that have come out that I wanted to look at on the issue of under.
It's all Fotis. She didn't know. That's what he's saying.
With tampering, for example, they are State versus Knox, KNOX, 201 Connecticut, appellate 457 in 2021. And they talk about State versus Jordan, which is in 2014, 314 Connecticut, 354. They talk about that's where it specifically says, even though the statute is not as clear, that you had to have acted with the intent to prevent the use of the evidence at an official proceeding for criminal investigation. And it construes in that respect the difference between that case and State versus Forshaw, Foreshaw, at 214 Connecticut 540, where there was some debate between whether it was a requirement or not. And I submit the Jordan case and then the Knox case make that clear. I also want to make one other last argument here. There is going to be some evidence suggested by the state that if Mr. Troconis made false statements or intentionally made false statements, which of course we dispute, but let's assume that based on the testimony, the jury could find that she made false statements during the interrogations. That evidence, Your Honor, was admitted for purposes of arguably consciousness of guilt. And we will be submitting a jury instruction, but they have to first find that it was intentionally false as opposed to based on either mistake, misremembering, being coerced, all those things that we've talked about. But the case law on consciousness of guilt makes clear, and the judge must instruct the jury, that consciousness of guilt is not evidence of the crime itself. So the state would have to prove separately that the defendant, that there was sufficient element of the crime in each element of the crime, and then apply whether, I'll use flight as the example. If a person runs away when the police come and somewhere in a group of people they find drugs, that fact of somebody running away is not evidence that the individual possessed those drugs or possessed it with the intent to sell. It's admissible to show a guilty conscience. And that would only be admissible if there was separately sufficient evidence of the underlying crime beyond reasonable doubt or crimes. Just one moment, Your Honor. Oh, the other case on Pinkerton that I wanted to cite was State versus Patel, which is the appellate court case 194 Con App 245, 2019. And then I'll also cite to the elements for conspiracy to commit murder, State versus Balbuena, B-A-L-B-U-E-N-A, which is 168 Con App 194, 2016. And conspiracy to commit murder, State versus Pinnock, P-I-N-N-O-C-K, at 220 Connecticut 765. Based on that, Your Honor, I asked that on each of the counts. I'm sorry, I thought I was done. I realized one other thing. There are 3 separate conspiracy charges charged here. I submit that the state has not shown any 3 separate agreements under any theory, and at the very minimum, the court is required, based on the evidence, to grant the judgment of acquittal as to 2 of them. And the way I understand the law, the court can leave in the most serious one. which would be the conspiracy to commit murder if the court does not agree with my other arguments. But the court must, based on the case law on the issue of a multiplicity of charges, they have not shown there were separate conspiracies at any time, haven't shown any conspiracy at all. They certainly haven't shown there were separate conspiracies. And based on all of that, Your Honor, I ask specifically, just on this last argument, that the court grant the judgment of acquittal as to count 2, count 4 as a separate argument. Thank you.
Thank you.
All right, now we hear what the state says about it.
Your Honor, good morning, and may it please the court. Your Honor, the defense argument seems to be that we have a different interpretation of the evidence and therefore grant us an acquittal. But of course, as the court knows, that is not the standard that the court needs to apply here. The court has to view the evidence in the light most favorable to the state as part of this motion, including drawing all reasonable inferences that a jury could find in favor of guilt. Including drawing all reasonable inferences that a jury could find in making a finding of guilt. So I want to just begin with the argument that the state has proven that Mr. Dulos is responsible for Jennifer Dulos' death, but that somehow the state has not presented sufficient evidence for a jury to find that it was actually an intentional killing. That is completely belied by the facts of this case, Your Honor. A reasonable jury can draw the following inferences. Number one, Mr. Dulos was motivated to harm Jennifer Dulos based on the fact that they were involved in a highly contentious divorce. Mr. Dulos drove his employee's Toyota Tacoma to New Canaan to commit this crime. He attacked Jennifer Dulos in the garage and killed her with at least 2 blows. It's been about a month, but you'll recall, Judge, we had the blood pattern expert who came in and indicated that there were at least 2 blows which were delivered in this case based on the direction of the blood pattern. By the way, the fact that he was in New Canaan in the first instance, Your Honor, is evidence of his intent because he had no reason to be down there. The children did not have visitation on that day, and the fact that he went down there in the first instance is evidence of his intent, including the fact that he took his employee's vehicle. State versus Moody does not stand for the proposition that the defense keeps citing. State versus Moody, I know the court knows this, but it's the totality of the evidence in this case that is the dispositive factor, including the fact that all of those presumptive blood tests subsequently tested positive for Jennifer Dulos' blood. So that's the compelling factor in this particular instance. A reasonable jury can also find that Jennifer Dulos was transported from her home by Mr. Dulos and her body was disposed of in some manner, which again goes to the intent in committing the crime in the first instance. A reasonable jury can find that her clothing was removed by Mr. Dulos and disposed of in the trash on Albany Avenue, thus demonstrating his connection to the blood, the clothing, and his act of murder. And I would just cite the court to State versus Richards, 196, Con. 387. The state does not need to prove the cause of death in a murder case merely that it was caused by criminal means. So in other words, the fact that the body has not been recovered does not mean that the jury can't find that there was homicidal violence in this case, particularly when you combine the blood pattern evidence with the cut clothing, with the fact of animus towards Jennifer Dulos and Mr. Dulos' DNA in a mixture of blood with Jennifer Dulos' DNA on that faucet. Now, counsel will say, well, there was no confirmatory test done. That's not the test. It's not whether or not a confirmatory test was done. The test is whether or not a reasonable jury could find. So here you have Mr. Dulos' DNA mixed on the faucet with Jennifer Dulos' DNA. It's a blood-like stain that tests positive for blood, which is strong evidence of his guilt. Now, that is, of course, evidence of Mr. Dulos' intent, but let's talk about the evidence of the defendant's intent. I would direct the court to State versus Soini, 180, Con. App 205. That was a conspiracy to commit murder case, and the court in Soini specifically talked about one of the factors, of course, for a jury to consider is whether or not somebody who is alleged to have entered into a conspiracy would have been motivated to enter into that conspiracy. So let's talk about all the evidence of the defendant's motive that the state has established during the course of this case. And I would just note also that there is no requirement in a conspiracy case that the state present a witness who comes in and says, I agreed or I heard an agreement. It can absolutely be proven by circumstantial evidence based on the fact that conspiracies by their very nature are done in secret. And there's a whole line of cases, Your Honor, that stand for that proposition. So the evidence of the defendant's motive here, obviously, number one, her boyfriend is in a contentious divorce with Jennifer Dulos at the time. In part, incidentally, due to the fact that the defendant and Mr. Dulos had an affair and Jennifer Dulos left the house shortly thereafter with the children. They were in a custody battle that necessitated the defendant having to leave the home whenever Mr. Dulos had visitation. She was not to be allowed around the children. During her interview, the defendant actually said that this had been 2 years of torture. She talked about applying for a restraining order against Ms. Dulos. She discussed the fact that her relationship with Mr. Dulos was suffering as a result. And in fact, the defendant told Mike Meehan that she had not moved to Connecticut for this. The defendant also told investigators that she was prepared to leave Mr. Dulos as early as December 2018, and the jury can infer that she was going to leave because of the fact that this divorce proceeding was driving a wedge into her relationship with Mr. Dulos. The defendant was obviously, a jury can infer, extremely upset and motivated to harm Jennifer Dulos, as evidenced by the fact that she stated, when referring to Jennifer Dulos, that that bitch should be buried next to the dog, thus demonstrating severe animus towards Jennifer Dulos and explicitly referencing her death a month or so leading up to Jennifer Dulos' disappearance. And even after Jennifer's disappearance, the defendant's animus towards Jennifer Dulos continued, as evidenced by the fact that she told Pavel Gomini that she was going to, quote, kill Jennifer when she turned up. Now, the defense will say, well, that proves she didn't know. The jury doesn't have to accept that. The jury can accept that as merely a self-serving statement in an effort to cover up her involvement in the crime, but while still expressing severe animus towards Jennifer Dulos. The jury can also infer, Your Honor, reasonably that the defendant had advanced knowledge of the murder and actively tried to help Mr. Dulos with his false alibi. After all, the defendant was home at the time or the approximate time of the murder and purposely, the jury can infer, answered his phone to help establish his alibi, as evidenced by the fact that Mr. Dulos wrote in his alibi script that he initially answered the phone. The phone call, of course, was from Mr. Dulos' friend, who subsequently refused to cooperate in the investigation, and that call, according to the data, had been arranged the day before. The defendant, of course, did not mention this call in her first two interviews, and in fact indicated in the second interview that she had not seen Mr. Dulos' phone at all. The defendant actively lied about Mr. Dulos' whereabouts on the morning of the crime, even after being told that Mr. Dulos was responsible for Jennifer Dulos' death. And the evidence is, if Mr. Dulos was in New Canaan killing Jennifer Dulos, which the defense has essentially conceded, although they don't concede the intent, that the defendant was home alone with Mr. Dulos' phone and manipulating it. That's the evidence. She's unlocking the phone. She's playing with the phone at times when Mr. Dulos is in New Canaan. And that, again, is something the jury can draw a reasonable inference that this whole thing with the phone call was a planned event. The defendant was in possession of his phone, waiting for the call that had been prearranged the night before. The jury can also infer, Your Honor, consciousness of guilt based on...
Okay, real quick. So the arguments that he's making are... Because what the judge is hearing right now is the defense's motion for acquittal. So what he's saying right now is all of this evidence is like the jury can look at this and say like this points to guilt. So because of that, it needs to go to the jury for deliberations. You can't just say there's no evidence that was presented that where they could look at it and say that this is, a possibility. For the acquittal, it's for the judge to rule on the acquittal. It's not like, a reasonable doubt thing. There's no reason. There's nothing that the jury could look at that would lead them to believe that there's a reason that she did it or whatever. Does that make sense?
That the defendant actively assisted Mr. Dulos in attempting to conceal evidence of the crime, thus demonstrating a consciousness of guilt with respect to the conspiracy to commit murder. And that, of course, serves as the basis for counts 2 through 6. The defendant, incidentally, says that the court at this point needs to make a finding that it was one conspiracy. They cited no case for that proposition, Your Honor. It's just simply false. A reasonable jury could reject some or all of these counts, and it's up to the jury to decide whether or not the state has proven each element of each crime beyond reasonable doubt. They cite no case for that proposition whatsoever. But nonetheless, those counts. The defendant, I guess, was claiming that because the state didn't indicate evidence of others being involved in crime, number one, that's not true because we have the testimony regarding Mr. Dulos' friend making the phone call, not cooperating, but also not required for conspiracy to commit murder. The only thing we have to prove, Your Honor, is that she agreed with one or more persons. That's the state of the law. So it's false to say that we somehow had to prove that she conspired with other people besides Mr. Dulos.
Virginia Crawford, thank you for the gifted membership.
With respect to the tampering counts, Judge, we have charged her under an accessorial liability with respect to that. The test is essentially that the defendant believed an official proceeding or criminal investigation was pending or about to be instituted, helped Mr. Dulos discard the evidence at issue, and acted with the intent to prevent the use of evidence at an official proceeding or criminal investigation. I'll direct the court to State v. Forsaw, which is 214 Con 540. In that case, evidence that the defendant had discarded a murder weapon before any contact with police officers or the judicial system was sufficient to convict the defendant of tampering with evidence. So there's no requirement, Your Honor, that actually an official proceeding ever begin or the timing of it, merely that the defendant believed one was about to be initiated. So what can the jury find with respect to counts 2 and 3? A reasonable jury could find the following: that the defendant agreed to assist Mr. Dulos in the destruction of physical evidence and assisted him based on the following. She was present at 80 Mountain Spring Road shortly after the Tacoma arrived and drove back and forth several times.
Your Honor, I apologize. The state may interpret have a moment. We're having a technical issue.
Certainly.
Technical problems.
And was committed and that she was actively helping Mr. Dulos, as evidenced by the fact that she brought cleaning supplies. A reasonable jury could find that she accompanied Mr. Dulos to Hartford and was present as he disposed of those items, and that she actually assisted him in the disposal of the license plates by opening her door at the exact moment that he opened his door and left it open until he dumped those license plates in the sewer. If you look at the video very carefully, Judge, what you're going to see is a vehicle there that she's attempting to block, and a reasonable jury can make that finding. She's trying to block the view of that particular vehicle. A reasonable jury could find she was aware of what was in the construction bags, as evidenced by her many lies about the entire day, including the fact that she was present at 80 Mountain Spring Road and was going back and forth repeatedly and apparently lighting fires, which is again consistent with the destruction of evidence. She actively assisted in the cleanup process prior to going to Hartford, including bringing cleaning supplies, which incidentally were consistent with those which were found in Hartford, including a green and yellow sponge, a broom or a mop handle, and black garbage bags, all found in Hartford that the defendant admitted to bringing to 80 Mountain Spring Road. The defendant's DNA is located on the opening of a bag that tested positive for blood, had Jennifer Dulos' DNA, and had duct tape, and was found amongst other bags matched to Jennifer Dulos' untimely death, specifically a bag that contained a bloody shirt and bra confirmed to be human blood that was forensically linked to the DNA of Jennifer Dulos. With respect to counts 5 and 6, Judge, a reasonable jury could find that the Tacoma was used in the commission of this crime, and the defendant assisted Mr. Dulos in his effort to conceal evidence found within and upon the Tacoma. As the court knows, the Tacoma was viewed on video surveillance leaving 80 Mountain Spring Road in the early morning hours. It was tracked on surveillance footage heading down to the New Canaan area. It was parked near Waveney Park in the general area where Jennifer's Suburban was found. Approximately 40 minutes or so after Jennifer's Suburban was viewed leaving her residence, the Tacoma was seen traveling north on the Merritt Parkway, where it essentially tracked right back to 80 Mountain Spring Road. A reasonable jury can conclude that evidence relating to the crime of Jennifer Dulos was inside of that vehicle based on, number one, her blood being present, and yes, they can make that finding on one of the seats. The defendant's acknowledgement that Dulos was cleaning the vehicle, and Dulos' paranoia and insistence that Mr. Ganini get rid of the seats from the Tacoma. Moreover, a reasonable jury can conclude that the defendant was at 80 Mountain Spring Road during the cleanup of the Tacoma, and in fact admitted to assisting Mr. Dulos throw away a paper towel that apparently was being used to clean the Tacoma. The fact that she says it's coffee is not dispositive. The jury can merely view this as a self-serving statement, especially in light of all the other evidence in her lies. The defendant took the keys to the Tacoma, and a reasonable jury can conclude that she took the keys to the Tacoma because she understood that Mr. Dulos had used it in the commission of the crime, and they wanted to keep the Tacoma in Farmington so that they could continue their efforts to clean up. The defendant drove in tandem with Mr. Dulos to the car wash, knowing that he was going to wash the car in an effort to conceal evidence of the crime. Again, a reasonable jury can make that finding, especially given that she initially tried to sort of fudge those facts to the police and lie about it and say that he'd called her to come pick him up. And then when she's pressed, she says, oh, well, maybe we went together. The Tacoma was extremely clean when it was found by investigators. So clean, in fact, that despite the fact that it was an 18-year-old work vehicle, there were numerous places where there was no DNA profiles at all, thus showing evidence of the destruction of evidence in the cleanup. DNA expert Kristen Maydell testified that DNA can be destroyed by wiping it or using water or shampoo. Thus, a reasonable jury can conclude that there was evidence destroyed in connection with this case. The defendant also showed consciousness of guilt with respect to this by not telling investigators that the Tacoma was at 80 Mountain Spring Road, thus demonstrating her understanding that this was used in the commission of the crime during her first 2 interviews. The defendant also failed to tell the police that this vehicle had been washed during the first 2 interviews, again demonstrating consciousness of guilt. With respect to the hindering count, Your Honor, obviously the defendant, by following Mr. Dulos out, meeting him at the car wash, and a reasonable jury can infer that she understood that the crime of murder had been committed. Incidentally, this is 5 days later, but certainly, Judge, a reasonable jury can infer based on all the evidence that she understood that that vehicle was evidence of a crime, and she picks him up and provides transportation, essentially through the use of her vehicle, back to the car wash so that these things can be done. And she also, coincidentally, her phone number is the number that is used on the call log, which again, a reasonable jury can view as an effort to distance Mr. Dulos from the car wash. Perhaps they thought that she wasn't under investigation, even if he was. And again, a reasonable jury can make all of these findings. So, Your Honor, again, this isn't a motion about we have a different interpretation of the evidence. That's what closing argument is for. The question for this court is, has the state presented sufficient evidence to proceed? And of course we have, Your Honor, based on our argument. Does the court have any questions?
Yes. The court is reviewing the information that the court read to the jury. That information was filed on or about October 5th, 2023. The court is reviewing count 5.
I apologize, Your Honor. I don't have a copy in front of me. If I just... Sure. Thank you.
And the information reads, the court is just going to read the pertinent part. On the 29th day of May 2019 in the town of Avon, in the area of 265 West Main Street, that being Russell Peters, the defendant, Michelle Troconis, believing that a criminal investigation conducted by a law enforcement agency was pending and about to be instituted, and an official proceeding was pending and about to be instituted, did alter, destroy, conceal, and remove a thing with the purpose of impairing its availability. What evidence did the state introduce on that count?
Yes, sir. The evidence is the car wash itself. And if I may just be heard on this, because I did hear Attorney Schoenhorn's argument, but we charged her as an accessory in this particular count, Your Honor. And I know I didn't think that this was going to be an issue, but I'm happy to provide the court with the case law. But essentially, by putting the accessory statute, we put the defendant on notice that that is a theory that we are pursuing. And so the court needs to view that count in light of that allegation that she was an accessory. And so the fact that the Tacoma itself was brought to the car wash, if a reasonable jury can infer that the Tacoma itself was used in a crime, then the jury can infer that she aided Mr. Dulos in the tampering of that evidence by providing him with transportation, by allowing her phone number to be used, and that the destruction of evidence happened. So there is no requirement, Your Honor, based on the way that we've charged this, that we prove that she actually altered the evidence herself, because we've charged her under an accessorial liability theory.
Thank you.
Very briefly, I just want to respond to a couple of things. I'm actually a little surprised to hear Mr. McGinnis say that the luminol was tested and confirmed to be blood on all these items. That's simply untrue. There were 3 items total that were tested. None of the others were tested. This all goes back to the suggestion they can infer it was blood from that is not only improper, but I submit that they argue that point to the jury. That's considered prosecutorial misconduct based on that. So I submit that that's just a erroneous statement. With regard to the bold assertion that Mr. Dulos was in New Canaan that day, and so therefore he wasn't home, I submit there's no proof of that. We concede he had something to do with the plan, but they cannot prove that it was Mr. Dulos who was there on May 24th, in light of the fact he was there on May 22nd. And therefore, they cannot, as I cited, I don't even hear the state referring to that recent Connecticut Supreme Court case on DNA that I just cited a few minutes ago. So, and about transfer DNA. But be that as it may, there is not evidence that all of these other items were tested and found to be positive for Jennifer Dulos's blood. If there's evidence of homicidal, let me rephrase that. Evidence of a homicide, that does not prove intent. That doesn't prove murder. It proves an untimely death. And a motive, even if a motive exists, is not equal to a conspiracy. There may be a lot of people that you might wish ill will to, but in the absence of either knowledge or actual overt action, it doesn't translate that into finding, well, if you don't like somebody, that's the motive to kill them. The argument that she, quote, actively concealed, unquote, evidence of the crime is also completely speculative and made up. The fact that there was a fire in a fireplace during the afternoon, the suggestion they can say, well, she must be burning evidence of a crime. She must know that there is a crime being committed, that therefore the fact that there's a fire in her fireplace is proof of that. I submit would be pure speculation. In fact, half of what I just heard is speculation upon speculation upon speculation. I would note that Mr. Gumiani, for example, did not identify the red truck that was on the side of Latham Road as being his. The only time he identified a vehicle as looking like his was somewhere on the Merritt Parkway. There's the one angle from the rest stop and I can't remember as I'm standing here whether that was Fairfield or New Canaan, but I believe it was Fairfield where he said yes because it has that bar in the front. We recognize that. None of the others are identified by Mr. Gumiani as being his vehicle. So I submit there is no evidence that that's the truck on the road. What's more important and kind of interesting, Your Honor, there's no evidence of when the Chevy Suburban ended up on Latham Road until 8:30 p.m. when it was discovered by the police. There is zero evidence it was there during the day. There's no vehicle. There's no one who passed by that saw it. There's no cameras from any buses that show it there at any other time. And we do have evidence that that a phone that's been paired to that vehicle since 2018, and which evidence shows she was going to see Dr. Geronimus. So that is her phone. The state objected to my asking Ms. Farber about that, but it's obviously clear in light of the testimony that that phone was Jennifer Dulos's phone paired to that vehicle at 2:56 p.m. on the afternoon of May 24th, 2019. And the state concedes that Mr. Dulos was in Farmington at least 1 o'clock or so on that afternoon of the 24th. The idea that, I'm not sure, I may have misunderstood Mr. McGinnis, so I apologize in advance, that he said that that they don't have to show who these unnamed speculative co-conspirators were. I don't know if he said that they didn't have to show which one of them she conspired with, or he said the opposite, that they don't have to name other people as long as they prove beyond a reasonable doubt that she conspired with Fotis Dulos. I also submit, Your Honor, because I prepared for that the state misread and misstates the holding in State versus Forshaw, which I also cited. In Forshaw, the defendant actually shot someone in the presence of numerous witnesses, then fled, then got rid of the weapon. In that case, the Connecticut Supreme Court held that it was obvious that there would be a criminal proceeding that was going to be commenced because she knew there were witnesses, and the fact that she fled from it was, it was obvious to anybody that there would be a criminal proceeding pending. We're talking about here what's basically hindsight bias, hindsight creation of what someone should have figured out after the fact based on what was happening at the time. At the time, there's no evidence whatsoever that Michelle Troconis knew what Fotis Dulos or anyone he conspired with or aided did to Jennifer Dulos on that day. And there's also no evidence. She did not provide. This is also.
Okay, real quick, because he's giving me a headache. He just said that the phone that connected to Jennifer Dulos' Bluetooth at 2:56 was Jennifer Dulos' phone. He said that the state won't say that, but they know it was Jennifer Dulos' phone. Did they not say, am I remembering this wrong? Did they not say during that it was a phone that, it was an Apple phone, but they didn't have the information on it? Like, so it wasn't one of the ones that had paired with it before. Did they not say that? What day was the phone? I want to go back and look at that. Whenever. But I got to look up and see when the phone Bluetooth stuff was. Because am I remembering that wrong? I felt like they said that whatever paired at 256 was an Apple ID that they couldn't recognize because it had not paired with it before or something like that.
She did not provide transportation to Mr. Dulos to go to the car wash. She was going to an appointment with her lawyer, and she picked him up at the car wash and brought him down to Westport with her, and he drove. That's the only evidence that's in this case on that point. Finally, there was no evidence of blood. I want to be clear in that Tacoma. None. There's no evidence she cleaned the Tacoma. She didn't even see Dulos cleaning the Tacoma. All she knows is he handed her a paper towel, said that he had spilled coffee, handed it to her, and she put it in a garbage bag. Whatever he was doing inside that Tacoma, there was zero evidence that she saw him. In fact, Pavel knew what he was doing. Pavel was told by Dulos that there might have been a hair of his wife in there, so he wanted him to take out those seats. So if anyone had knowledge that there may be evidence of a crime in there, it's Pavel Gumieni and not Michelle Troconis. The only difference, I guess, is that Mr. Urso, Attorney Urso, representing Mr. Gumieni, had the wherewithal and obtained immunity in exchange for cooperation. That's something that Ms. Troconis did not ask for and did not receive, and that's the only reason I submit she's sitting here today. The only reason she's sitting
What?
The state talks about...
He just said that the only difference between Michelle and Pavel, the only difference, the only reason that she's on trial and he's not, is because his attorney asked for immunity and hers didn't. That is wildly inappropriate and also goes against every single thing that has been presented in this case in the last 25 days.
Well, we charged her, the court had a question about the tampering at Avon, at the car wash. They said, well, we charged her as an accessory to alert the defense. But again, you have to act with the exact same state of mind. So the leap of logic that the state is asking this court to jump to, or for that matter, the jury to come to, she must have thought there was some evidence that would lead to a criminal prosecution or a criminal proceeding because she picked him up. She left at the same time, but that she picked him up at the car wash, and we don't even know what time that was. We just know the approximate time that the call went in to pick her up, for her to come get him. But she wasn't even within range that he could just jump into a car and leave. You have to call her on the phone. And the one last thing that I think there is absolutely no evidence, and it's also, again, improper, Mr. McGinnis just said that the defendant allowed her phone to be used at the car wash. That is simply, definitively a false statement. There is no evidence she allowed her phone to be used by Mr. Dulos when a number was written down by the car wash employee. And if the court will recall, just a couple of days earlier, Mr. Dulos' phone, his regular phone, had been seized by the police. And it is just as likely, not just as likely, it is extremely likely that at that moment he didn't know the phone number, the one that he was now using. So he used one that was in Ms. Troconis' possession when they went down, when they were about to go down to Attorney Bowman's office. So based on that, Your Honor, I tried to respond to the arguments. I'm not going to fight or even contest the fact that there was some kind of untimely death that the jury could find was based on this evidence. I'm just submitting that there is not the evidence that was just submitted by Mr. McGinnis, and the idea that one could put assumption upon assumption, on speculation upon speculation, and reach that conclusion based on this evidence is not even warm gruel. It is absolutely, there is no logical inferences that could be drawn that could lead to the conclusion that Michelle Troconis knew anything about what's either happened to Ms. Farber or what Fotis Dulos was doing in a criminal conduct in relation to her disappearance. Thank you.
Just quickly, Judge, counsel completely misstates the state's position on these things. What I've said is that a reasonable jury can draw these inferences, not that these things are definitively in the record at this point. Obviously, a reasonable jury can infer that the defendant allowed her cell phone to be used as evidence in the totality of all the evidence, so he misstates it. I also never said that all these items were tested positive for blood. And I don't think I even used the word luminol in my argument, so I guess we're just making things up now as we argue to the court. But I did just want to follow up on one issue, Judge, State versus Vasquez, 68, Con-App 194 on the accessory liability issue. I just wanted to give the court one case. I didn't have a chance to research all of them. Just on that count 5 issue.
Thank you. The court will just begin by indicating what the court has to find in a motion for judgment of acquittal.
Thank you, Vicky Cho.
Of course, the court does not have to determine that the state has proven each and every element of each and every offense beyond a reasonable doubt. That's the province of the jury. The court has to determine whether there is sufficient evidence on each count to go to the jury. Now, in so doing, the court cannot, in this court's view, allowed to filter into its decision what the court thinks of any witness's credibility. The court is not making credibility determinations in determining how it will rule on a motion for judgment of acquittal. What the court is required to do and is able to do is to determine what, if any, reasonable and logical inferences can be drawn from the evidence that has been adduced. So the court is going to address the motion in just broad strokes. This is in no way a marshaling of evidence concerning intent of the defendant. The jury can reasonably consider that the defendant's remark that Jennifer Dulos should be buried next to the dog is evidence of motivation. The jury need not conclude that. The jury can consider it. That statement was made before A24. The jury can consider certainly that the blood found on the cut garments in the trash on Albany Avenue is evidence of Fotis Dulos' intent to restrain and kill Jennifer Barbara Dulos. The jury can reasonably conclude that because the defendant indicated that Dulos was at home on the early morning hours of May 24th, but indicated later on that he was not, that she knew where he was going to go on May 24th and was covering for him. The discarding of evidence on Albany Avenue is an indication that the defendant knew the purpose for which those items were being discarded. The jury can conclude that even though the defendant did not drive Fotis Dulos to Russell Speeders, that there probably was an arrangement whereby he told her, "Pick me up later at Russell Speeders," which means she knew the reason he was going to be there. The jury can conclude these things. Again, the court is not required to assess the strength of the evidence. The court is just required to determine whether or not there is enough evidence to go to the jury. Now, concerning the remarks about multiple conspiracies, the court believes the Second Circuit has concluded that a conspiracy terminates when the central purposes of that conspiracy are attained. So, for example, if the central purposes of the murder of Jennifer Dulos have been attained on May 24th, that's the end of that conspiracy. Then there's another conspiracy. So, and that conspiracy is to hinder prosecution or tamper with evidence, for example. So the court is not persuaded that the state cannot charge multiple conspiracies. And it is too early to consider at this point any arguments concerning a vacator of any of the convictions, if there are any convictions. So the court finds that there is enough evidence to go to the jury on counts 1 through 6. And the motion for judgment of acquittal is denied. Time is 11:25. We'll resume the session at 11:40. We'll stand in a recess.
All rise. This honorable Superior Court now stands in.
All right. So it is going to go to the jury, obviously. Motion denied. No surprise there. Let me pull up. All right, I'm going to do, hold on, give me a second. Give me a second. Change some things around on my screens because I know how you people are. Sandra Oliver, sorry, I just now saw that. Denied. Denied. There we go. Stop pressing buttons, Brandi. Okay. Get it together. There we go. All right, because I know how y'all are. And nobody will be able to focus on anything because everybody's going to be talking about all the other trials going on because nobody can ever focus in here because everybody's just as ADD as I am. I'm putting the verdict watch for Adam Montgomery in the top. Alrighty. There we go. Look at Lucy. Look at that dog. Look at this. Not a care in the world. Not a care in the world. Oh, to be that free. Look at her. What? She's laying in there with her new little ball that Mermaid gave her. Too cute. Okay. All right. Let's skip forward to when they come back from their break. And defense will be starting.
Conclude by Friday. I'm just indicating the witnesses for each day. If they're not
Monday. The court understands that the defense has at least one witness scheduled for today and probably will not conclude until Monday. Is that correct, Attorney General?
We are endeavoring to complete by Friday, but based on just everyone's schedule and whatnot, we may not conclude till Monday morning, but it's very likely we might be able to conclude by Friday. I'm just indicating the witnesses for each day. If they're not as long as anticipated, then we might be done by Friday. We're trying to have everyone here by Friday, but we would have to cancel if it was running late.
Thank you.
Your Honor, if I may just be heard briefly. Counsel has informed the state last night a few names of who may be called today. And prior to them coming out, the state wanted to raise an issue with respect to, I think, two of the witnesses outside the jury's presence. So I would ask Your Honor if you should do that now or to hold off.
Well, right now, let's just continue with the scheduling.
Yes, Your Honor.
The court is going to assume that the defense will conclude sometime on Monday morning. So what the court will ask both sides to do is file with the court proposed jury instructions by the close of business on Friday. The court will anticipate that the defense will present its last witness on Monday. After the defense's last witness, we will go into the charge conference, which has to be on the record. The court then anticipates after the charge conference, the court will proceed with the contempt hearing. Tuesday morning, closing arguments.
Tuesday morning closing arguments.
Attorney Manning.
Yes, Your Honor. Counsel informed the state yesterday that they intend to introduce, I'll start with the Farmington police officers, Your Honor, with respect to the evidence concerning the manner of death of Fotis Dulos and essentially the suicide, Your Honor, as well as a suicide note that was found next to him. The state's position, Your Honor, is that this evidence is completely irrelevant to the case. It has nothing to do with Michelle Troconis or the charges that she is faced with, and the state is seeking to be heard on if that evidence is going to be presented, in what way, and some feels that there should be an offer of proof, and I'm requesting an offer of proof with respect to the Farmington police officers that were subpoenaed today. Counsel also provided the state with the name of a Cheryl Briere. That name appears nowhere in any police report or in connection with this case in any way, shape, or form. So the state is asking for some kind of offer of proof as to what the relevance is of Ms. Briere. I would indicate if it is character evidence, it would not be for truthfulness because the defendant has not testified as of yet. So the only thing the state could assume, and I don't like assuming when it comes to this, is that she would be a character with witness or some kind of character trait at issue. I just feel at this point, Your Honor, since Ms. Briere's name is not in any way on any form, report, or in any way connected to the case, the state is requesting either an offer of proof or that she be precluded from testifying.
Do you wish to respond to Attorney General?
Yeah, I don't have my witness list in front of me. I don't want to call it a witness list of names. I just want to refer with that first, if I may. Her name is on the list, Your Honor, so I think that the state's claim is unfounded.
I just want to be clear, I'm not claiming she's not on the list. She was. She's not relevant to anything in this matter. She does not appear on any police report, any statement given, anything that has to do with this case. So the state has no notice as to the content of her testimony. As such, the state is asking for an offer of proof outside the presence of the jury in order to find out exactly what she will be testifying to.
I will just recall what the court said when we objected to witnesses who were irrelevant. The court said they'll take it up as the witness is on the stand if there's a particular question. We filed, I can't even remember how many, 20 motions in limine. The court did not require the state once to do an offer of proof, not once during their case. So the fact that she's now asking for that for witness just because she did not, or the state did not go out and investigate people that they've had since October. And I know we weren't required to provide a list, but this name was definitely on the list. There were a number of names we put on that list. The state cannot now claim, well, we didn't know when they failed to investigate the names on the list. As the court is well aware, the defense could have simply called people. We don't have to give the court a preview of what each person is going to testify to. They can object if something is asked that is not relevant. I know the rules of evidence. We certainly wouldn't be caught, even if, and I know this is not what we're doing, but even if we were going to put on evidence of, excuse me, of character, even if that was, we would not be required to have that person write out a letter of recommendation to what they were going to testify to. So this is not only unnecessary, but it's also unheard of as far as I'm concerned, Your Honor.
Well, the court will first address the representation by the state that a witness is to be called by the defense to testify about the manner of death of Fotis Dulos. How is that relevant?
Well, first of all, this is not this morning's testimony, Your Honor. So again, I didn't get any opportunity.
Now, this is something that has kind of been talked about a little bit before. How is Fotis's, he's asking now, how is it relevant how Fotis died or him committing suicide? How is that relevant to the defense's case?
You have the defense, the state has not once had to make an offer of proof towards any of their witnesses. The purpose of presenting the evidence of the fact that he is unavailable as a witness, the state was allowed to state on the record that Mr. Mawhinney was unavailable. I'm entitled in our case to show the circumstances under which he is not available in the case. I do not intend these police officers to testify as the cause of death. It's the fact of death. There's going to be a death certificate that I intended to introduce to show he's not available. So it's relevant to the circumstances, certainly more relevant than I would submit half of the state's case was about the lack of evidence that they were able to present.
Well, so, is not a stipulation that Fotis Dulos is deceased?
No, Your Honor, and we're not willing to stipulate to that.
Well, the court question is, for what reason are you calling the Farmington police? State representative is to indicate that Fotis Dulos is deceased. So, and then the court understood you to just say that you're not willing to stipulate to that.
I'm just going to note that at no time did this court require the state to give
the question. The question is, you just indicated to the court that you wanted to call the police officer to testify that Fotis Dulos is deceased.
No, Your Honor, I didn't say that. I said that
perhaps the court misunderstood.
Yes, it's the individual officer who found Mr. Dulos in his vehicle on the date in question. That is the purpose on that, for the record, would be January 28th, 2020. I've heard the state say, well, the jury may have questions about it. There's been some testimony about the circumstances. This is to complete that circle, if you will. And then I would be introducing a death certificate and a decree of death as a certified copy of the decree of probate death, just to close that circle of information. And that is the purpose of that testimony.
The court does not understand what the circle is. The court is under no impression that the jury would have questions about whether or not Fotis Dulos is deceased.
So, again, I made my offer. I didn't think I should have to, but I did. If the court is indicating that we cannot present that portion of our defense, at least it'll be on the record. But I'm indicating that we would intend to put on evidence of where he was found, that he was taken to the hospital. And then there's also the fact, which I would then, once we presented that, there is the suicide note where he exonerates Ms. Troconis. I recognize that it doesn't come in under as a statement in contemplation of death. In other words, not a dying declaration, but I would attempt to present sufficient evidence that it would come in under the residual hearsay exception, that there's no other way to get that statement in. The court may, at that point, in its discretion, determine it doesn't meet that, but I have to put on the evidence in order to reach that point. Again, for the first time in this case, only the defense is being required.
I did not repeat that. The court was not aware of what the defense counsel was attempting to do. It was simply the fact that Fotis Dulos is deceased. The court would not allow that testimony because it's not relevant. The fact that Fotis Dulos essentially wanted to exculpate the defendant is another matter.
If I may be heard on that, Your Honor.
Well, that's going to be a matter that comes up at the time.
That's fine. Thank you.
So remember that suicide note said something like he's going to end it because he can't stand to spend another day in jail for something he didn't do.
Again, if the matter was simply Fotis Dulos is deceased, court would not allow it. Which witness is the defense prepared to call at this time?
Robert Haynes, Your Honor.
Oh, that's Hutch. That's Hutch.
We can bring the jury in, please.
Hutch is the one who owned the pond. He's the one that had the cookout. They call it the pond. It was like the lake that was nearby.
So would you raise your right hand, please?
Judge, the jury isn't in yet.
Counsel stipulate, please.
Yes, Your Honor.
Yeah.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Robert Haynes, RobertHaines.
Thank you, sir. You may be seated.
Hutch.
Thank you. Good morning, Mr. Haynes.
Hi.
You go by another name. I know your formal name is Robert Haynes, but can you tell the jury what you're often referred to as?
Yeah, Hutch. Hutch would be great.
And you're here pursuant to the subpoena, correct?
Correct.
You and I haven't spoken until about a day ago?
Nope.
And you're familiar with Michelle Troconis?
Yes.
You haven't spoken to Michelle Troconis since 2019?
No.
Do you own a property with a leak or pond on it?
Yes.
Can you tell the jury a little bit about that property and where it is?
We have a water ski pond in Avon, Connecticut. It's a private membership. We're all very serious water skiers. You would join the club, and it's really kind of a community. It's a very small community. We all pretty much are there most days, and we are tournament skiers, so we practice during the week, and a lot of times some of us will be competing on the weekends and traveling, and there's about 30 members, and it's a big family.
I'm going to ask you a few questions just about the pond and the area. You call it a pond. In terms of compared to other water ski areas, is it a relatively small pond or a large one?
It is small. No, it's very small. A lot of people will ski on open lakes. This pond is about 1,600 feet long and maybe 300 feet wide. So it's not a pond where you can go off and just really ski and go for long runs. It's a competitive site where you're either in a slalom course or you're on a jump, or some people will trick ski. So it's a 3-event competitive lake versus like an open water lake. Very small.
Are you familiar with the term short setup?
Short setup, yeah. So the short setup is in most places or most lakes, you can get up behind the boat. This is referring to slalom skiing. You get up behind the boat, you have a minute or two to adjust your shorts or whatever, and then you're in the course. You go through gates, you turn around 6 buoys, and then you drop at the end of the lake. Our lake is incredibly short in that you get up and you don't have time to do anything. You are immediately in the gates. You go through the 6 buoys, and then you're in the water again. So you literally come up behind the boat, you ski for 16 seconds, and then you drop down, and then you do it again. So you're not even skiing for a minute.
And this property, that you own this property?
Yes.
Is it private property?
It is.
How long have you had the ski club?
We've been skiing there for about 45 years, I would say. I'm 58. I started skiing there when I was about 10. The club itself is probably, 25, maybe a little bit more, 25 years old.
And is the pond open year-round?
No.
Can you tell the jury a little bit about how the season works, when it starts and when it ends?
It's very weather dependent, but the earliest we could possibly open would be the end of March if weather cooperated. We have some really serious skiers in our club that will put on heavy wetsuits and ski in very, very cold water. So they might get started at the end of March. Typically we wouldn't really start skiing until May, and we would ski always through September and a lot of times to the end of October.
And during that period of time when you're open during ski season, is it throughout the week? Is it Monday through Sunday or just on the weekends?
It's every day. So it's every single day. There's people there all the time. With 30 members, there's a lot of people in our club that might find odd times to ski when they know there's not a crowd there, because if you go on a Wednesday at 5 o'clock when people get out of work, there might be 10 people waiting to ski, and that could be an hour and a half or 2 hour wait.
Is it more crowded on the weekends?
It's more crowded on the weekends, but on the weekends, everybody has all day. So they can hang out and not, you're losing daylight on a Wednesday. So we may only be able to ski till 8 o'clock at night. So from 5 to 8, everybody's trying to get their ski set in. On a weekend, there may actually be more people there, but you have all day to ski. So nobody's worried about getting their time in.
Would people make reservations to be able to ski, or would they just come down and show up?
Pretty much, they would just come down and show up. So, yeah.
And while people were waiting to be pulled on the skis or to ride the boat, would they often hang out? Is there an area for people to hang out?
So we have a very large dock, and we do have like a picnic area with a tent over it, and we have a couple areas to hang out. But yeah, everybody would socialize in one place or another, and you're waiting. You could be waiting 2 hours to ski, so you're there. You're there just kind of hanging out. You'd get in and out of the boat. You'd take turns driving the boat. You take turns riding, because you always need a driver and you need somebody riding. So you're working ski lines and, all that kind of thing. So it's busy. Everybody has kind of something to do. But at the same time, these guys, the people that are in the club, most of the people have been members there from the beginning. So it's a family. You're hanging out, talking to them, and, a lot of times talking smack.
And would people bring dinner or lunch down there sometimes?
Yep. Yep.
And when you say people had been there mostly from the beginning, are you familiar with Fotis Dulos?
Yes.
Was he a member of the ski club?
Yes.
Do you remember when he joined the ski club?
I can't tell you exactly what year, but I'm going to say it was 2005, maybe. I know he moved to Connecticut with his first wife and joined our club. And I got to say it's 20 years ago.
Do you know the name of his first wife?
Hillary.
Had you met Fotis Dulos prior to 2005?
Yes, I've known him. He was a water skier, so I've known him, through water skiing, probably 10 years prior to that.
So since about 1995?
Probably, yeah. So the first time I spent any time with Fotis was when I got married. Boy, don't ask me for a date because my wife's out there. I'm going to get in a lot of trouble. But we flew to Greece on our honeymoon, and I had Fotis's name, and we met Fotis one day, and he showed us around. Our honeymoon was in Greece, and he showed us around Greece. That was really the first time I ever spent any time with him.
And was Fotis a competitive water skier?
Yes.
Were you also a competitive water skier?
Yes.
Did you see him at water ski tournaments?
Yeah, definitely.
In state as well as out of state?
Yes.
Do you know whether Fotis often traveled out of state for competitive water ski tournaments?
He did. He was, in his younger years, he was on the Greek team. So he water skied for Greece. So those are European tournaments. And then he would ski tournaments all around the country in the U.S.
Did you also come to know Fotis's children?
Yeah.
Do you know whether they water skied?
They did.
Do you know whether they traveled out of the state for competitive water ski tournaments?
They did all the time.
And was that with Fotis?
Yes.
Had you in fact seen them out of the state at competitive water ski tournaments?
Yes.
Had you had the opportunity to observe Fotis at the water ski club with his children?
Yes.
Can you tell the jury a little bit about whether or not they water skied together and for the amount of time that they may have stayed at the club, not as to what was said, but just your observations? And to narrow it down to a certain time period, I'll say between 2015 to 2019.
So I'm going to object, Your Honor. This is irrelevant. It's a vague question. It's
relevance counsel.
Just as observations and awareness of Fotis during that time and what he observed.
Not relevance exchange.
Did you know Jennifer Dulos?
Yes.
Did Jennifer water ski?
No.
Did she hang out at the pond ever?
Objection. The time frame, vague.
Well, the question is ever. So overruled.
You can answer.
Rarely. She would come down. So her kids would be, most of the time, her kids would come to the pond with a nanny, and they would ski with Fotis, and their nanny would be on shore taking care of them. It's not that Jennifer was never there. She was there every once in a while, but she wasn't there most of the time when the kids were there. It was always a nanny.
Prior to 2017, did you ever socialize with Fotis and Jennifer?
Objection.
Round.
Relevance 2017, prior to 2017.
Relevance, counsel.
Your Honor, I'm getting into Mr. Haynes's knowledge of the time period when Ms. Troconis moved into the house and Ms. Dulos moved out of the house. That's going to be my next question.
Well, the objection is sustained.
Did there come a time in 2017 when, do you know where Fotis Dulos lived in 2017?
Jefferson Crossing, right? Yes.
Is that where
Yes.
Mr. Dulos lived at the time? Did there come a time when Ms. Dulos no longer lived at Jefferson Crossing?
Objection.
Well, what's the ground, please?
Relevance, it calls for speculation.
Well, if there was a friendship, it would not call for speculation, so overruled.
You can answer the question.
I don't recall him ever. Well, he was a builder, so he lived in a lot of homes. But in that time frame, I don't remember him moving out of that house.
Do you recall whether Jennifer moved out of the house
Yes.
in 2017?
PG, thank you.
Did there come a time when you met Michelle Troconis?
I met Michelle very briefly at a water ski tournament in Florida. Fotis had his kids down there. I had my kids down there. And I was briefly introduced to her. I that had to have been 2016, maybe?
So prior to 2017,
Yeah.
you recall meeting
Maybe.
with Ms. Troconis?
Maybe 2017, yeah.
Do you know if Michelle Troconis moved up to Connecticut?
Yes, she did.
And do you know when that was?
There was definitely a long gap after after I first met her. I feel like it was probably a year or maybe 2 years after that. Don't hold me to the time frame, but I know she moved up a little bit, a ways after my first encounter with her.
Did around that time period, did Fotis ever talk about an intention that he moved Michelle up here?
Yes, he talked about it, about having a girlfriend, and eventually he was going to get her up here, yes.
Wow. Did Michelle ever join the ski club?
Yes.
Do you know when she joined the ski club?
I think it was 2017. I think it was 2000. It was either 2017 or 2018, but she was a member.
Would you see Michelle at the pond frequently in 2017?
Yes.
Would you speak with Michelle when she was at the pond?
Yes.
And you said that at the pond there were sometimes social events?
Yeah, not planned, but there was so many of us around all the time that, regularly, there were summers where we eat dinner down there every night, and there's always other people around. So whether it's simple as getting a pizza or doing something a little bit more where everybody's bringing something, yeah, we had, social gatherings all the time. It wasn't a planned gathering. Everybody would ski and then just hang out.
So between 2017 until early 2019, had Michelle and Fotis attended some of these social gatherings?
Sure.
And had you socialized with Michelle and Fotis outside of the pond on occasion?
Yes.
You had told the jury that Fotis had water skied with the children at the pond. Did there ever come a time when Fotis was unable to ski with the children at the pond?
Objection.
Brown.
Calls for relevance, calls for speculation, hearsay.
Well, court is not clear on the relevance.
Your Honor, I'm going to link it. It's subject to connection. If I can ask a few follow-up questions, I'm going to establish Mr. Dulos' behavior related to the custody and visitation.
Well, there's no foundation for questions about custody and visitation with this witness.
I need to ask some foundational questions, Your Honor, related
You
to
can
that.
ask the direct question.
Did there come a time when you learned that Fotis could not see his children?
Objection. Calls for hearsay.
Well,
Okay, so far he's given us a whole lot of nothing. He's told us about the club and all of that. But I think the main thing to take from what he's said so far is he's mentioned a couple times that them hanging out there was like a family, because you spend only 16 seconds on your actual like ski thing and then you go down again, but you could spend 2 hours waiting to get on the boat. So most of your time that you're at the ski club, you're there with all of these other people and talking and conversing. And so there's, what do you say, like 30 people or something. So you're getting to know them and you become close to them. So I think that that was them laying the foundation to show how he knew Fotis and Michelle, like on a personal level, so that he can give any kind of information about them.
Overruled.
I remember a point where, I felt like it was sudden because I wasn't completely knowledgeable on everything that was going on, but I remember that Jennifer at one time left the home, and I believe she took her children with her.
Do you remember, without getting into what was said, Fotis's demeanor or emotion or attitude towards not being able to see his children?
Objection.
Overruled.
Oh, he was upset. He was very upset. I mean, those children were his life.
I'm going to fast forward now to 2019.
Okay, I just want to point something out. If those children were his life, he should have behaved in such a way as not to destroy their lives, number one. Number two, keep in mind that Hutch owns the ski club. Fotis, there's all kinds of documents. I went over this in the intro to this case. There's all kinds of documentation about how Jennifer was frustrated because she thought that Fotis was trying to train the kids to become, world-class skiers, and he had them on this crazy strict, schedule and all that stuff for training for all of this. So I think that for him to say those kids were his life, for me, my instinct is to roll my eyes, because you don't kill their mother and, then kill yourselves and ruin, taint their childhood with that and, give them trauma for the rest of their lives if they are, so much of your life. But I digress. But more than anything, keep in mind, he owns the ski club. So he is seeing that side of Fotis, where Fotis is there with his kids, interacting with his kids about skiing, which is something that he really wanted them to partake in. So that view is a little bit skewed for that reason. I want to keep that in mind.
Prior to the ski season getting into full swing, did Fotis ever express to you an immediate expectation that he would be skiing with the kids at the pond again?
Yes.
And that he was expecting to be able to take the kids to repeat in water skiing again?
Object, Your Honor. This all calls for hearsay.
Expectation of immediate future conduct.
Which he would say and express, which is a hearsay statement.
Well, at this point, the question is the question, did Fotis Dulos talk to this witness about his expectations? Is that the question?
Yes, Your Honor.
And if I may, Your Honor, when, what time, and again, it's a hearsay statement about what he is expressing, his statement at a specific time.
I can rephrase that, Your Honor. In early 2019, did Fotis express an intention to be competing with his children again?
Object, is that January? Is that February? Object on time. It's a vague
the
question.
question is in 2019. So the court is going to overrule the objection.
You can answer that.
He was expecting to get his kids back into skiing and being able to spend more time at the pond and skiing with them again. He did not mention competitions.
Do you recall when in 2019 that was?
Okay, so this is going back to that thing they keep hinting at, that Fotis, had something going on with the court, that he believed he was about to get custody of the kids and all of that. So they're saying that in 2019, this goes to that version of events, that narrative that they keep trying to paint about how Fotis somehow believed that he was going to get custody of the kids. He was going to somehow go from supervised visitations only to full custody. But they said, him saying that Fotis said in 2019, early 2019, he expected to have the kids around a lot more, and they were going to be able to ski a lot more and stuff. It goes with their version of him saying that he was going to have them more. or have custody?
That was that Thursday night.
And when you say that Thursday night, was that May 23rd, 2019?
Yes.
Can you tell the jury about his demeanor or attitude towards that expectation?
I mean, it was when Fotis and I talk, 90% of our conversation is water skiing. We never did business together, really. We never had any outside life other than water skiing. He was definitely devastated when he didn't have his kids skiing. So I think he was excited that he was making progress, and he felt like he was making progress. And he definitely said he thought he would have them at the pond a lot more. Prior years, he didn't have them down there at all. And I think he thought he was going to be able to get shared custody and be able to spend weekends with them skiing, and even, sometimes during the week. I think that's what he was hoping for.
Okay, and that was around May 23rd, 2019. I want to talk about May 23rd, 2019, because, can you tell the jury if you saw Fotis Dulos on May 23rd, 2019?
I did.
Can you tell the jury a little bit about those circumstances?
Dinner. We were invited to his house.
Okay, pay attention to this part because I want to hear what he says about this. This is that dinner the night before. Remember when Fotis had to leave to go get more meat, but then he actually went to that workhouse for 7 minutes, and Kent was in the area and all of that. So this is that night, the night before Jennifer went missing.
I wouldn't call it a dinner party. It was 6 of us. Just a gathering, nothing formal. And it wasn't last minute. We probably talked about it a couple of days earlier, and we met him. We went over to their house for dinner.
Who were the 6 people who were in attendance at, is this Fort Jefferson?
Yes.
Who were in attendance at Fort Jefferson on May 23rd, 2019?
My wife and I, a local realtor, Stefan, and his wife, Beth, and Michelle and Fotis.
And your wife's name is?
Erin.
Do you remember what time you got there that night?
I honestly don't. I think it was somewhere around 6:30. My guess.
Do you remember what you ate for dinner?
I'm pretty sure it was chicken. It was a Greek salad, maybe French fries. We definitely had a bottle of wine.
Do you remember Fotis stepping out at any point in time in the evening?
I do not.
When you saw Fotis that night on May 23rd, 2019, do you recall whether his hair was short or long?
I think it was short.
Okay, now he doesn't remember him leaving. He says he doesn't remember Fotis leaving, but remember, Fotis was already gone by this point. Fotis went, I think it was like 5:30. So if Hutch didn't get there till 6:30, then he wouldn't have known that Fotis left.
And had you ever seen him before in previous years with a very short haircut?
Sure.
And did people at the ski club often have short haircuts?
Yeah, we have a couple members in our ski club who would not shave their head, but definitely cut it way back for the summer.
Were you surprised at all about his haircut?
Not really. It was, going from long to short is always a different look, but I wasn't surprised. I didn't think anything of it.
And was anything unusual about that dinner?
No.
Even looking back in hindsight, was there anything unusual about that dinner? No. You talked a little bit about Fotis's mood. Did he seem happy?
Yeah, it was just, happy. He wasn't, he was very friendly. We hung out. It was very relaxed. It was.
I want to point one thing out too. Don't you think it's a little bit odd? He's saying that he talked to Fotis on the 23rd again about, and Fotis was talking about how he was going to have the kids there a lot more, even some during the week. And then the next day, Jennifer goes missing, and we know that Fotis assumed he was going to get custody after she went missing, based on his conversations with, even talking to the police about, them being at her mom's and stuff instead of with him. So he's talking to him the night before Jennifer goes missing about how, I'm about to have them a lot more. And then all of a sudden she goes missing. I think that could also appear to the jury as, instead of like, oh, he thought he was about to get custody, it could appear to the jury as, oh, he knew he was about to try to get rid of her.
About it whatsoever.
Even now, looking back, all those.
Even now, looking back.
In hindsight.
Yes.
Do you know what time? Do you recall what time you left that evening?
I'm guessing it was somewhere close to 10 o'clock.
Do you know whether you left before or after? You said Stefan and Beth.
Mm-hmm. I feel like I left before they did. And the reason I think that is because I remember walking out and seeing a nice car in the driveway and saying, real estate must be good.
Is Stefan in real estate?
Yes.
Okay. Do you recall leaving of your own accord, or was anybody wrapping up the dinner?
No, I think no.
After you left, so that's May 23rd, 2019, did Erin leave her purse at the house?
Yes.
Can you tell the jury a little bit about the circumstances surrounding how you found that out and what happened next?
We drove home, and I think when we got home, Erin realized that she had forgotten her purse, and instead of, she wasn't overly worried about it. Instead of, it wasn't like at a restaurant, it was in somebody's house. And I don't remember whether she, I feel like she may have texted Michelle that night and said, I forgot the purse. It might have been the next morning. She may have been the next morning. I don't remember.
And how did the purse was the purse eventually returned to your wife?
They had texted between themselves and arranged to have Michelle drop it off in my office, which she came by and handed me the purse.
This is the one part of the alibi.
When you say she came by the office, is that at the pond?
Yeah, it's in front of the pond. I owned a business there, a self-storage facility with an office up front. So it was my place of work. So I was working, and she just walked in and handed the purse.
All right. Do you know if she handed the purse directly to you?
She did.
Okay. Do you recall talking to her at all when she came?
It was very brief. I feel like she was going to the grocery store, mentioned on my way to the grocery store, but it was a 10-second conversation, not even.
Was there anything unusual about her demeanor at the time?
No.
Even looking back in hindsight?
No.
So that weekend, that was Memorial Day weekend, at some point you learned that Jennifer was missing.
Mm-hmm.
And at any point in time that weekend, did Michelle or Fotis come to the ski club?
We did not see them Saturday, but I saw Michelle at the pond pretty much all day on that Sunday. I believe Fotis was going to see his kids or try to see his kids Sunday, so he was not there. Michelle spent the day at the pond with her daughter, and then Fotis, I think later, it was probably late afternoon, early evening, showed up at the pond.
And can you tell the jury a little bit about what Michelle's demeanor was like on that Sunday at the pond? So
I believe there was state police at her house. I don't know whether they were in the house or parked out in front, but I know she didn't want to be there. So she was obviously agitated. I remember she tried to ski. I mean, the water was still very cold, but she was upset, and she was definitely teary-eyed.
And you said Fotis came later in the evening?
Yep, Fotis, I don't think he was able to see his kids, so I think he ended up back at our place, or back at the pond. I would say sometime, it was later, maybe 5:30, 6 o'clock.
Did Fotis, when he came, seem upset or concerned?
He was upset that he didn't see his kids, for sure. Yeah, he was upset.
But that was your impression, that that's what he was upset
I feel
about?
like he was upset that he wasn't able to see his kids.
During that weekend and the days that followed, was there a lot of media presence at the pond?
Yes, it was unbelievable.
Was there a heavy police presence at the pond?
There was heavy everything at the pond. So we had, I mean, it was nonstop. So you have podcasters calling, you have reporters driving in, calling, the state police, showing up at my office to look at surveillance. Our pond it's sacred ground to us. We have 30 people in our club that love that place. And the state police come in with dogs, and they search the place with dogs, and then they put a boat in the water, and they go over the whole pond with a boat looking for a body. It was awful.
And it obviously still is upsetting for you.
Yeah, no, it was probably one of the most painful times of my life.
And they searched your property pretty thoroughly.
Yep, I gave the state police came down early in the week, and I gave a tour and showed somebody and told them all about the pond. And then I feel like it was a couple days later, they got a search warrant and they came down with dogs and taped off the whole place. And there had to have been 20 police officers just doing their searching the whole place. And then I don't know if it was a couple weeks later or it was when it was, but they came and did it again, this time with a boat, to put a boat in the water.
And you cooperated fully with that?
Absolutely.
Did you speak to Fotis around that time?
The only real contact, I mean, around, so yeah, I mean, during that week, no, I didn't see him at all.
In May of 2019, do you remember Fotis ever saying something to you about Jennifer having left in the past and he expected that she would show up? Effect on the hearer listener, Your Honor.
Well,
then it's irrelevant.
This is not going to be a street corner argument. The court knows of no exception to the hearsay rule effect on the hearer. In this court's view, that's folklore. That's not the law. The then existing emotional or mental condition is an exception to the hearsay rule. This is not being offered, as the court understands it, for the truth of the matter is overruled.
You can answer that question.
So Fotis would look at me and over the few times I saw him, he would say, I did not do this. I did not do this. And he did at one time tell me that Jennifer had run away at some point earlier in her life, and I don't know the details of it. And he said she's doing it again.
Wow.
I have 1 moment, please, Your Honor. I have no further questions. Thank you.
Cross-examination, please.
Thank you. Good afternoon, sir. How are you?
Good.
My name is Michelle Manning. I represent the state. I'm going to ask you a couple questions, okay?
Mm-hmm.
Now, briefly, you talked a lot about on Direct About you own the pond.
Yes.
Okay, and that's the ski club. What is the ski club called?
Old Farm Skiers.
Okay. And it's members only?
Yes.
Okay. And Fotis Dulos was part of that water ski membership?
Yes.
Correct? Okay, and Michelle Troconis was as well?
Yes.
And now, you also own the storage facility that's around that pond?
Yes.
Okay. And with respect to water skiing is important to you, correct?
Yes.
Yeah, you've been doing it a very, very long time,
yes.
Correct? Okay. So, I mean, you own a pond. I think you described everybody as a community,
yes.
Would you say? Okay. And Michelle Troconis was part of that community, wasn't she?
Yes.
And in fact, you talked about many times that you would just hang out on the dock, maybe have dinner together, things like that. Is that correct?
Yes.
And you would talk to her a lot during the time she was there, correct? You'd socialize.
We'd socialize, but in a group.
In a group?
Yeah.
Yeah.
And, like,
in English?
Yes.
Okay. And I want to ask you some specific questions about the party on May 23rd. It was planned a couple days in advance. That was your testimony, correct?
I think so, yes.
Okay. And you've had, you didn't know that Stefan Reich and Beth Johnson were going to be there that day in advance, did you?
I feel like I did.
You feel like you did?
Yeah, I think there was going to be 6 of us, yes.
Okay. Was Stefan Reich part of the water ski club?
No.
Okay. And Beth Johnson wasn't either?
No. That was the first time we met them.
That was the first meeting that night? Okay. And you were invited by Fotis Dulos?
Yes.
Okay. And you got there, I think you testified around 6:30?
I'm guessing. I don't know. I just don't remember exactly what time.
It's been about 5 years, you would say. Is that fair to say?
Yes.
Okay. And when this first happened, there was a lot of media attention?
Yes.
I think you talked a little bit about it. You mentioned this was a very difficult, I think your words were, this was the hardest thing that you've ever gone through in your life?
Yes.
Was the media attention?
Mm-hmm.
Okay. By the way, you see the camera behind me?
Yes.
And it's been, have you been watching on TV?
No, haven't seen a single second of it.
Okay, but have you noticed the news reports?
No, I won't watch it.
You won't watch it at all, right? Because you're very close to Fotis.
Yep.
Okay.
Well,
it's very, very big part of your life. I think you said 30 years.
Yes.
Yeah. Okay. Now, at the dinner party that night, the kind of impromptu dinner party, you'd say, right? It wasn't very Formal?
No.
Okay. It was you, your wife?
Yes.
Okay. And Stefan Reich, correct?
Yes.
Beth, I think she was Johnson at the time. Yeah. And Michelle Troconis and Fotis Dulos, correct?
Right.
Okay. And I think you testified that there was nothing odd about it. Those were your words, correct?
That's correct.
Okay. But Fotis talked about the fact that he really couldn't wait to get that. He had an expectation he was going to get the kids again, right? Is that correct?
Yes.
And he talked about, I think you testified, you talked about the fact that, on May 23rd, he was excited. He was going to take the kids water skiing again. I think that's what you said too, right?
Yes, he said he was making progress where never before has he been making progress to get them, get custody, or to get visitation.
Never before? You remember him saying that?
Repeat that?
You said he's been making progress where never before
up to that point, I don't think he really had the kids at all. And not even, he would be able to see them once in a while, but it wasn't very consistent.
And on May 23rd,
he mentioned that he thought he would be able to get more visitation and that we might be seeing the kids at the pond, where we haven't in a long time.
Did you discuss the plans to murder Jennifer the next morning at the dinner party?
Say that again?
Did you discuss the plans did Fotis Dulos and Michelle Troconis discuss the plans to murder Jennifer at the dinner party on the 23rd?
No.
Did they discuss with you at the dinner party to dispose of evidence of the murder in the garbage cans of Albany Avenue?
No.
Argumentative.
Well, the question is essentially the leading question that was the intent to murder Jennifer Dulos discussed at the dinner party. And your objection is argumentative. Well, the clear answer from this witness is going to be no. So the objection's overruled.
Did you have those discussions, sir?
No.
And what about the plan to use the Tacoma and clean it afterwards? Did he discuss that?
To what?
To use a Toyota Tacoma and then clean it afterwards. Did he discuss that with you?
No.
And you talked a lot about the media influence on the pond and how the police coming with, did you say they searched the pond one day and then they came back with a boat and divers? Did they do that? Okay. And that was the worst experience of your life, them searching for?
It was an awful experience. It was an awful experience.
Yes, awful experience. Searching.
The whole thing's an awful experience. Yes.
Of course. You watching the pond being searched for a dead body of a mother of 5 was awful for you. We understand that.
Sustained.
And nothing further, Your Honor.
I have a few follow-up questions. The state had asked you about speaking to Michelle Troconis, and she spoke English, correct?
That's correct.
Did she sometimes struggle to find the right words?
Sometimes.
And she would ask what certain things meant?
Yes.
And the state had asked you about Fotis's communications about making progress. Were you aware at the time that a custody report had come out?
Objection.
Sustained.
I was about to say.
Did Fotis talk specifically about court proceedings in terms of making progress?
Objection.
Well, did he talk about it? The answer is either yes or no. The witness does not remember, so that's overruled.
Do you want me to re-ask that?
Yeah.
When you had mentioned that Fotis Dulos was talking about making progress, was that in the context of the custody proceedings in court?
Yes.
And the state
According
asked
to
you
him.
some questions if you were part of some plan to do something nefarious, and you had said no.
No.
You've known Fotis for decades,
Yes.
right? And even in hindsight, looking back, there was nothing to alert you to the fact at the time, right?
No.
Nothing at all.
No.
No further questions.
Nothing further. Thank you.
Mr. Haynes, you may step down.
All right, Hutch. He gone. I don't think that did a whole lot of good. I think it could have honestly had the
another defense
opposite.
witness available at this time.
Yes, we won't get done with that witness, but we can certainly start unless the court wishes. I figure we should start. Yeah. And I've had Attorney Felsen is, I think, bringing him in at this point.
Because the jury's going to hear that, the night before she went missing, he was like, hey, I'm about to have the kids more. Like, the jury's going to hear that and be like, okay, well.
We solemnly swear or solemnly and sincerely affirm this case in the future that the evidence we shall give concerning this case shall be the truth, the whole truth, and nothing but the truth. So, I'll be glad or upon penalty of perjury.
I do.
Can you please state your name and spell it for the record?
Stefan Reich, Stephenreich.
He was one of the other ones at the dinner party.
You may be seated. Thank you.
Thank you.
Good afternoon, Mr. Wright.
Good afternoon.
Would you please indicate to the members of the jury what you do for a living?
I'm a real estate agent with Coldwell Banker in Avon, Connecticut.
Where do you live?
Avon, Connecticut.
With whom?
My fiancee, Beth Reich.
How long have you been a real estate agent?
Since 2009.
Can you tell the jury a little bit about what kind of real estate, there's different kinds of real estate agents, right?
Yeah, you have commercial, residential. So I work primarily residential, new construction, land acquisition for building, luxury properties, and that's most of what it was.
What area, is it mostly in Connecticut?
Yes, mostly the Farmington Valley of Connecticut. So Avon, Farmington, Simsbury, West Hartford,
Can you tell me whether or not you knew Fotis Dulos?
I did, yes.
Did you know Michelle Troconis?
I did, yes.
How did you get to know Fotis Dulos?
Actually met Jennifer while she was walking the first set of twins, Petros and Theodore, at the development they lived in Canton in Griswold Farms. I lived there as well. I met Jennifer while walking the dog a few times and seeing her around the neighborhood.
And for the record, when you say Jennifer, who are we talking about? What's the full name?
Jennifer Dulos, Jennifer Farber Dulos.
And at the time you met Jennifer Dulos, was she married to Fotis Dulos?
Yes, she was.
Did you become, could you just tell us whether or not you had a friendly or unfriendly relationship with the Duloses back then when you met Jennifer?
No, very, very friendly.
Can you just describe briefly, you said you met Jennifer when she was walking her twins in a stroller?
In a stroller,
Could you just describe in a little bit, did you have a conversation, just see her, what did you do?
I saw her, we just, started a conversation, they were new to the neighborhood, I was new to the neighborhood, I moved from New York, we just, kind of hit it off, just having general conversation. I had seen her subsequently a few times while she was, she would walk the babies in the strollers quite often, and she had suggested that we come over to their house with my ex-wife at the time to just have a drink and get to know each other.
And did you do that?
Yes, we did.
Approximately what year was that, if you recall?
I would say probably 2008.
How far away did you live from the Duloses back then?
Less than a half a mile.
Was it the same neighborhood or just on the same road?
The same subdivision, same neighborhood. We were on one street, they were on the next street over, down the road.
Did you also develop a social relationship with Fotis Dulos other than just going there once for a drink?
Yes.
How would you describe the relationship as it developed over the next few years?
The relationship between whom?
Maybe I should separate them. Between you and Jennifer Dulos and you and Fotis Dulos during that time?
We had gone out to dinner several times. I mean, we just, would mostly go out to dinner and socialize. And we'd always talk. And I was transitioning work-wise from a family business, and Fotis had suggested that, I possibly get my real estate license and do sales and marketing for his company.
Did you go into real estate and get your license because of Fotis Dulos' suggestion?
I did, yes.
Could you tell us what was the employment of Mr. Dulos at that time when he made that suggestion?
What did Fotis do for a living? Is
Yes.
that the question?
Yeah.
He owned a company called Four Group, which was, a higher end luxury home builder in the Farmington Valley.
When you got your real estate license, did you have any professional dealings with the Four Group?
Once I got the license, I obtained all of the listings that the Four Group had.
And would that indicate that you had income from and through the Four Group?
Correct.
During that time frame, did you continue to maintain a social relationship with both Jennifer Dulos and Fotis Dulos?
Yes.
Do you water ski?
I have. I am not a water skier. I snow ski, but I have water skied with them. I think maybe 3 times, but that's just not really my thing.
So when you say with them, did Jennifer Dulos during that time frame water ski?
I water skied at the pond, I believe, 2 times with Fotis at the pond in Avon, and then I did water ski with Fotis and Jennifer in Greece when we were there for Clay and Noel's baptism.
So do you know what year that baptism would have been of Noel? She was the youngest daughter, correct?
She was the youngest one, yes.
Do you remember approximately what year that was?
I don't remember the exact year.
What were the circumstances of you being in Greece at the same time as the Duloses back then?
They invited us to go there for the baby's christening and to have a vacation.
Where were you water skiing with the 2 of them?
I don't know. It was an area where Fotis had skied kind of growing up, and we skied with some friends of his, and Jennifer was on the boat, and she skied as well.
Do you recall whether or not Fotis Dulos was involved in any competitive water skiing activities during that time where he'd actually compete?
He was, yes.
Did you ever observe or go to I don't know if it's called a tournament or a meet
I don't believe I've been to a competition. I mean, I have seen him ski at the pond, a couple times, but I don't know if that was a competition per se.
Did you ever observe any medals or ribbons or any other certificates he got as in his competitions?
Yes, I've seen that.
Where did you see them?
Probably Facebook post or, after an event, he would tell us how he did.
You have how many children?
I have one child, one biological child.
Was your child of similar age to any of the Dulos children?
My child was the same age as the second set of twins.
And for the record, how old is your child now?
15.
Did your child go to school with any of the Dulos children?
Yes.
Where was that?
The Farmington Valley Academy, Montessori, and Avon.
Happy anniversary, Brett.
Did there come a point when the Duloses moved from your neighborhood to another neighborhood?
Yes.
Do you recall when that was?
I don't remember the exact date now.
Were you at the time working for a real estate company or were you on your own?
No, working for a real estate company. I started with William Ravis from when I got my license, I think 2009 to 2017, and then I've been with Coldwell Banker since.
Did there come a separate time when you went to work for the Ford Group as an employee?
That is correct. I still maintained my real estate license, but I was not a 1099 with Ford Group. At one point, I was a salaried employee.
When you say 1099, if you're a real estate agent, how do you earn money if you're selling property through that's being built by a builder?
You're earning commissions, and then you're getting a 1099 from the broker at the end of the year.
Tell the jury about your employment at Ford Group, where you actually were you were salaried.
Correct.
Could you just tell the jury how that came about?
Fotis did not like the fact that I was earning a lot of money in commission on the sale.
Oh.
You actually were interviewed
What
by
happened?
the police at some later point, correct?
No. Oh, hold on. It skipped us to live. So annoying.
Or custom homes.
You said you didn't like that you were earning so much money. During this time period, what was the usual commission that you would earn for the sale of a home?
It depends. It's a percentage of the sale of the home, but it was more not outside of Ford Group, but the homes that Ford Group sold, some of them were millions of dollars, and the commission numbers added up, and Ford Group didn't participate in that money. That money came to me. I believe I earned it. I worked hard to sell those properties.
But if the real estate commission was based on the price that the house sold, is that correct?
Correct.
You would earn more money if the house was more expensive.
Correct.
Did the Ford Group tend to build expensive homes?
Yes.
How long or what years did you work as an employee for the Ford Group?
I believe 2014, sometime in the year till probably January 2017.
During the time you worked there, what was your actual responsibility and job?
Sales and marketing of the existing homes that we had, maybe speculative homes, marketing of homes that were, quote, to be built. Well, these were paper listings that we would sell a land build package to a potential client. I'd help out with renovations that the Ford Group was doing, land acquisition, working with the municipalities to subdivide land, so working with the town, working with planning and zoning, whatever was needed.
Was there a difference between a custom-built home and a speculative home, as you just put it?
Yes, a custom home is a home we're building for a specific customer that they've given deposits and it's their home, versus a speculative home where the company, Ford Group, is putting up the money in hopes of selling it as quickly as possible, preferably during the time of construction, so that the carry cost would be minimal to the company.
During the time that speculative homes were being built, what was your role while you were an employee?
Well, there were speculative homes, custom homes. Like, the role never changed, regardless of what homes were being built.
I see. Did you meet with prospective buyers yourself during that time?
I did, yes. Not by myself, but mostly with Fotis together, Fotis and I.
Do you know when you stopped working for the Ford Group?
I believe it was end of December, January 2017.
Well, end of December of 2017 or the end of?
No, it was either the December 2016, January 2017.
Could you indicate to the jury what were the circumstances for you leaving the Ford Group?
He terminated me.
Can you tell me
Oh,
why?
he fired him.
He wanted all the employees to sign a non-compete agreement, and the non-compete agreement was like, it was just beyond the pale of what it should be. It was incredibly restrictive.
Maybe the jurors know what it is, but maybe you can just explain what a non-compete.
Okay, let's just point out that all of this testimony is like bad for Fotis. I mean, it's making him sound controlling and like, I mean, showing his character.
Agreement is or was in your case.
It basically said, I'm an at-will employee, so Fotis can terminate me at any point. And if I would have signed the non-compete, the way it was written, it basically prevented me from being a realtor. It prevented me from using any subcontractor the foregroup used. It prevented me from using any architect that foregroup used, and it prevented me from contacting any client. And a lot of those clients were my clients that I brought to the foregroup. So it was just, I heard it was not enforceable because of the language, but out of principle, I just was not prepared to sign it.
Good for him.
And how did you find out you were being terminated?
Fotis wanted everybody to sign it. He said, if you don't sign it by Monday, don't show up for work. And I didn't show up for work.
Did it change your relationship with Mr. Dulos for you to be terminated under those circumstances?
It certainly did. It certainly changed, the business component of it, because I lost a lot of the listings, not all of them. I think I had like one or two of the multiple ones that were out there. So yeah, it had an impact.
During the time just before you left or were told not to come in the December of 2016 or early January of 2017, were you still in touch with Jennifer Dulos?
I don't know if I was in touch with her. Most of the social interaction was when we were like visiting with both of them together, like going out, or if they had an event at the house that we would go to. So I didn't see her on her own outside of Fotis. Yeah, maybe saw her at the grocery store or whatever, and give her a hug and a kiss and say hi, or see her at the school. But it was mostly the relationship was with both of them.
Did you continue to socialize with the Duloses while you were an employee?
While I was an employee, yes.
Including going out to dinner and showing up to events and parties?
Yeah, we went on vacations together. We went to dinner together. They had events at their house. We had an awards thing for home builders that we would go to every year.
How would you describe, while you were an employee, the relationship that you observed between Jennifer and Fotis Dulos?
It was positive. I mean, we'd go out to dinner. They would sit very closely together. They would always share an entree. But it seemed like it was a good relationship.
Did you become aware at one point that Jennifer had moved out?
I did.
And how did you find out about that?
I think Fotis told me. I don't remember exactly, but when she moved to New Canaan, I found out about it.
Did you have any reason to believe that that was going to occur before she moved out?
Can you repeat that?
Yes. Did you have any inkling that Jennifer Dulos had planned to move out before you found out she actually had?
No.
Did you have any contact with Jennifer Dulos after she moved to New Canaan?
I did after Hilliard died. I reached out to her to express my condolences because he was
After who died?
After her father, Hilliard, passed away.
And what was the nature? Just describe I don't need the substance, but how was that in terms of was it cordial?
It was very cordial. I just said, I'm so sorry for the loss of your father. He was a great man. He helped, the company very much. I've met him many times and I thought he was an amazing person and I was sorry.
And how long was that conversation?
I don't remember.
After you stopped working for the company, did you still have a business relationship?
I still had a business relationship. He gave most of the listings to a couple other agents in the area. And then over time, the listings started coming back to me.
Same kind of home, same kind of construction?
Yes, correct.
Same
just under a different dynamic, that it was just, I'm representing him as a realtor. There was no other relationship, and that was it.
Back to getting a 1099 and a commission?
Correct, yeah.
Your Honor, I'm going to move on to another subject. Perhaps this might be a good place to break.
Thank you. Ladies and gentlemen, we will resume the session at 2 o'clock. Please do not discuss the case.
All right. So we are almost caught up to live time now. Now we're only like half an hour behind.
Can I have the witness?
Yes, please. You can bring the jury in, please.
It don't sound good for hold on. I'm going to do a new poll. Now y'all always there's always somebody that hits the thing wrong. But I'm curious. Pay attention to the options. I'm going to do a new poll.
Council stipulate?
Yes, Your Honor.
Yes.
Thank you.
Mr. Wright, I think that when we left off, you had gone back into work as a realtor, but you were still working on projects of the from the Ford Group. Is that right?
That's correct.
Were there any specific properties that you were the exclusive agent for after you left Ford Group? Let's limit it to Farmington in case there are more.
I believe it was just, I can't remember if I lost 80 Mountain Spring temporarily. I remember I kept 585 Deercliff, and then I did resume 80 Mountain Spring.
So let's just talk briefly about 585 Deercliff. I'm not going to show you a map. The jury has seen the maps of the area several times. So where in relation to Jefferson Crossing was 585 Deercliff?
If you exit Jefferson Crossing, you would make a right, and that would be Deercliff. If you make a left on Jefferson, that's Eli. So you would make a right. It's probably a quarter of a mile down the street on the left on the view side.
Where approximately was the town line between Farmington and Avon in relation to Jefferson Crossing?
If you make a right out of Jefferson Crossing, it was very shortly after that, within 100 feet, I believe.
And 585 was in Avon?
Correct.
And 80 Mountain Spring was in
Farmington.
When you were how long was it that you remained the real estate agent for the marketing of 585 Deercliff?
Until it was sold.
Do you know when it was sold?
I don't know the exact date, but within the last 2 years.
So since 2019?
Yes, correct.
Can you describe what condition that property was in prior to it being sold?
Significant disarray.
Do you know why?
Fotis's mother died at that location, and previously he had used it for, like, when he had friends from Greece come over. His mom lived there at some point. I believe after that event happened, he just kind of let the place go. In all honesty, it was a tear down anyway. Like, that house more than likely would be purchased, and then it would be demolished, and a new home would be constructed on that piece of property.
Was it a choice piece of real estate?
Stunning, beautiful.
Could you just describe for the jury, because I don't think they've seen that aspect of it.
It's a 4.49 acre parcel in Avon, 550 feet of road frontage on Deercliff, which is, one of the nicer streets in the area. And it had just, sweeping views of the Farmington Valley. So views, location, acreage, road frontage, kind of had it all.
Was it was it facing the west?
It was facing west. So you're on top of the mountain looking west, looking down on the Farmington Valley.
And the property itself, was there a significant drop off that permitted these views?
Yes.
Could you just describe that rather for the jury?
Well, you had the house, and then you had a backyard, and then it dropped off significantly.
A cliff?
I wouldn't say a cliff, but pretty steep.
Was it at the top of Avon Mountain?
It was, yes.
You said that you had 80 Mountain Spring as you were under contract, or you were the realtor for that property as well?
Correct.
You said you lost it for a period of time?
After I was terminated, I believe he gave it to somebody else, and then I believe I did reacquire the listing, and then subsequently sold it.
Were you the listing agent in 2019 for 80 Mountain Spring?
Yes.
Were you familiar with the work that was being done to convert 80 Mountain Spring into a property to be sold?
Absolutely, yes.
Could you indicate to the jury a little bit about the property? They've seen photographs, they've seen aerial and drone footage, but could you describe what this house was and how it was converted?
Well, I did sell the property to the Ford Group from the original owners of that. Well, I don't know if they were the original owners, but I represented Ford Group to purchase the property. The house was very dated, needed a lot of updating. Some of the rooms were very choppy. On the third floor, there were like 5 or 6 bedrooms, a living room, kind of very small. I mean, the house it's a 100-year-old house. So we purchased the home. Ford Group purchased the home, hired a well-known architect from Fairfield County, and did just a complete remodel of the house. I mean, top to bottom, everything was redone.
Was the house demolished or was it reconstructed and expanded? Could you explain?
Reconstructed and expanded. The original house had a 2-car garage that was actually below grade, so you would park underneath the house and have to go upstairs to get to the main level. What Ford Group did was they added a 4-car garage on the east side of the house and had a very large bonus room above that. So they added a 4-car. They got rid of the basement garages, added a 4-car garage plus the bonus room above that 4-car garage as an addition to the original home.
How much acreage did that property have?
I don't know exactly, but around 7.5 to 8 acres in total.
Do you know whether or not that house in May of 2019 was completed? That is, was construction completed?
It was, yes.
Was it being marketed at that time?
It was, yes.
Had there been showings of that house?
Yes, there was.
Incidentally, if there was a showing for the purchase of the house, were you present usually?
If the listing came through the MLS, if there was another agent that wanted their client to see the house, I would be notified because I would have to approve of the showing per se. And Fotis did insist that the listing agent be present at all showings. It makes it a lot easier to talk about the highlights of the house. And there was so much work that was done. He felt, and I felt as well, it would be vital to have me there to kind of explain the work that was done, all the attributes of the house, and answer any questions. So on showings that were originated, per se, through the MLS, I would be present.
Were there times when a real estate agent might show that property to someone that you were not present for?
The only circumstance that would be is if Fotis was showing that house as a representative sample of what a custom home could be. So if there was a client that was interested in building a custom home, they could, sometimes Fotis would show him that house to say, clearly for this case, not the outside, but on the inside, this is the quality of our work.
In other words, they would not be seeking to sell that house, that property through a different agent. They would show it as a representative of his work. Is that what I understand?
Correct. And they've done that with Fort Jefferson, and they've done that, could be any of the properties.
In fact, was Fort Jefferson Crossing for sale technically at the time that Fotis was living there in May of 2019?
I'm not 100% sure.
If there was a for sale sign out front, would that suggest that?
Yes.
Shown in
Yeah.
videos?
It had been on and off the market, yeah.
Okay. When you worked for the Ford Group, how often would Fotis be in the office when you were there?
Most times, unless he was traveling, he was usually there.
Did he work long hours that you observed?
Sometimes.
When you came in, what time did you usually come in when you worked?
8:30, 9 o'clock.
And when you came in, did you often see him there already at work?
Yes.
And after you left in the evening, what time did you usually leave?
4:30 to 6 o'clock, depending on what we were doing.
And when you were working there, was Fotis still often working after you left to go home?
Sometimes, yes.
You said he traveled. Would you just tell us a little bit about how often he traveled while you were working there?
Towards the end, when I was working there, travel definitely increased. Miami, go skiing, competing. I know he went internationally to competitions, but it seemed at the end he traveled more.
While you were still working there, did you ever have conversations with him about whether his children would be competing?
He did mention, yeah, I believe some of the children did compete. I think Petros and Theodore did.
Water skiing?
Yes.
Was that nationally or internationally, if you know?
I don't know. I think maybe both, but I'm not 100% sure.
Did you know the Dulos children?
Yes.
Was the office part of the house, or did it have kind of a separate space and entrance?
It was a part of the house. I mean, they designed that house to have a home office. There was kind of an employee subcontractor entrance on the right side of the porte cochere, which is the breezeway, which goes from the front to the back of the house to that parking area. So we would always enter the house through that door on the right side, up the stairs and into the office. But then you could get to the main house from, I think the east side of the office went to one kind of sitting area on the second floor. You go down the hallway to the bedrooms, or there was a staircase down which went to the mudroom and towards the kitchen.
When you were working there, did the employees tend to wander into the residential portion of the house?
No.
It was basically separate?
Well, I mean, you could physically walk there. We just, we didn't.
I want to ask you specifically now about whether or not you continue to socialize with Fotis after you became the realtor and were no longer working for him.
I did, yes.
What kind of socialization or social activities did you engage in with him at that point? That is,
Go
after you left?
go out to dinner or go to the house once in a while.
And at the time, did you have a partner?
Yes, Beth.
Okay, could you just indicate, Beth, what's her whole name?
Beth Johnson Reich.
Are you now married to her?
No.
Would you socialize together with Beth and with Fotis?
Sometimes with both of us, sometimes independently.
Do you recall a time sometime in 2017 when Michelle Troconis had moved into the house?
Yes.
Did you ever see her when you were at the office for real estate related matters?
I believe so.
Did you talk with her?
I'm sure I did. Yeah.
Did you socialize with her and Fotis?
I did.
Did you socialize with her separately, that is you and Beth, with Michelle without Fotis?
No.
How would you describe your relationship with Michelle Troconis after she had become part of the household?
I mean, I think I've only met her 6, 7, 8 times, but it was always positive, friendly. I mean,
was there a time in 2019 where Mr. Dulos would talk to you about the status of his custody battle or custody dispute with Jennifer?
Objection.
Still trying to make this happen.
Well, it calls for a yes or no answer, or perhaps the witness does not remember, but at this point, it does not call for use. So overruled.
He did, yes.
Could you just describe what in general he would say about the process to you? And it's not being offered for the truth, it's the fact that it was said.
Well,
Objection.
the court understands the phrase, it's not being offered for the truth, but if the court cannot see other than being offered for the truth, the court is going to sustain the objection. What did he say about the custody battle? If it's not offered for the truth, what is it offered for?
It's being offered to show how Mr. Dulos was projecting his optimism towards the situation, and that's the purpose, not to the actual truth.
Well, then the question is, first question that was asked, did he discuss with you the custody matters that concerned him? The answer was yes. The next question, based on what counsel said, need not deal with content. It's his response to whatever custody issues were occurring at the time. For example, this is just the court's view to avoid a hearsay objection.
Coughing.
Was he aggravated? Was he happy? Was he enthusiastic? Was he expectant?
All right, let me ask a question that would encompass what the judge's concerns are.
Okay.
Did you, the preliminary question is, did you have such conversations with him about it?
Yes.
And that would be in around April and May of 2019?
Even before, but
in that time frame, could you, using as opposed to his words, could you describe his demeanor, attitude, his outlook about it?
Can you put a time frame
Yeah.
on that? Because
End of
I've
April
seen
into
different
May.
emotions.
Yes. April into May of 2019, that time frame.
Positive emotion.
Did there come a time, did you become aware, at least, that there had been a report that had been issued, without going into what it is, that there had been a report on the custody matter that he had seen?
Objection, Your Honor.
Sustained.
Did there come a time when you were invited to dinner in May of 2019?
Yes.
Could you tell the jury a little bit about how that came about?
We were actually supposed to have dinner with them on the Tuesday prior to Thursday.
So that we're clear, are we talking about the week that, did you become aware at some point that Jennifer Dulos had been reported missing?
Yes.
Would this have been in that week just prior to that?
When we had dinner?
When you had the discussions about dinner?
That would have been the week before we actually had that dinner on that Thursday night.
Okay. Yeah. So how did it come about? You were just beginning to say you were supposed to have it on a different
We were
week.
supposed to have dinner on Tuesday, and then I mixed up the custody schedule with the kids. So that week we have alternating schedule with the kids. So one week we'll have them Monday, Tuesday, one week we won't have Monday, Tuesday. So we had the kids Monday, Tuesday. We were supposed to have dinner on Tuesday. I let them know that I mixed it up. I can't do it. We don't have the kids Wednesday, Thursday, but Beth coaches her kids' soccer team. So would Thursday work? So he said, yeah, come over Thursday, 5:00. we'll come to his house. We were going to look at some rugs for Michelle, and then the plan was to go to a Japanese restaurant in Avon.
Now, there was, just to clarify, when you talk about visitation and custody, we're talking about your children, not Mr. Dulos.
Yes, correct. Yes.
Okay. So the plan was set to get together at what time?
5 o'clock.
And were there email exchanges with regard to that?
There was text message exchanges. Yeah.
Can you tell me whether or not, well, who did you go with, first of all?
With Beth.
Do you know approximately what time you arrived?
I don't know exactly, but if we were supposed to be there at 5, I probably would have got there at 5 or a couple minutes before.
When you first arrived, where did you first see Fotis Dulos when you arrived?
I was heading north on Eli towards Jefferson Crossing. And prior to us entering Jefferson Crossing and making a right into Jefferson Crossing, Fotis was leaving. So I passed him on Eli Road prior to entering Jefferson Crossing.
Prior to passing him, did you stop and have some conversation near the intersection?
Yes.
Could you just tell the jury what that was about?
Objection.
Well, what the conversation was about is just what was the topic. The court will allow that. Overruled.
He just said, "Oh, I'll be right back. Go head on over, and I'll see you in a little bit."
Did you say anything to him about him leaving at that moment?
But yeah, I mean, he was like notoriously late. We used to call it Fotis time, So I was like, "Oh, classic Fotis." I'm coming and he's leaving, and he said he'll be back shortly, and head on in.
When you said that if the time was 5, you would have been there at that time or earlier. Do you have a habit with regard to punctuality?
Yeah, I like to be punctual.
Was there any reason that you would have been delayed or not be punctual that day?
It's possible, but not likely.
So when he left, did you continue on to the house?
Yes.
And did you go to Fort Jefferson?
Yes, we did.
You pulled into the driveway?
Mm-hmm.
Did you pull into the back?
Into the back, yes.
So just tell us what you did when you went in.
Went in, and I think we greeted Michelle, and I don't remember exactly play by play, but we did. But she was selling these like really cool rugs from South America, like kind of cowhide rugs. So we went early to purposely just go and look at the rugs to potentially purchase. And then the plan was to go to dinner.
And we being who exactly?
Beth and I.
You said the plan was to go out to dinner originally, is that right?
That's correct.
Did you end up going out to dinner?
No, we did not.
So would you tell the jury what actually happened in terms of, did you eat? Let's start with that. Did you get to eat?
Yes, we ate dinner there.
Would you explain the circumstances, how that came about?
What came about?
How you ended up eating. Where did you eat?
We ate outside on the patio.
What did you have?
We had steak, French fries, and a salad.
Now, Mr. Dulos told you in the intersection on Eli Road that he'd be right back. Did he come right back?
I believe he came back shortly thereafter, yes.
Did he stay or did he go out again?
No, he did go out again.
What was the circumstances where he went out again?
He said he needed to get more meat to, facilitate cooking for everybody.
Did you see him leave?
I maybe saw him left the house. I didn't see him depart, but yeah.
Did he come back at some point?
Yes.
Do you know how long approximately he was out?
I don't know. Half an hour, something like that. I don't know.
Incidentally, are you familiar with what's called the Little Stop and Shop in West Hartford?
Yes, I am.
In relation to where Fort Jefferson Crossing is, can you tell us whether that would be the closest grocery store?
I'm trying to think of the closest.
Let me ask a different question first. There's now a Whole Foods in Avon, is that right?
That's correct.
Was it finished and operating in 2019?
No, it was not.
Okay, so if that didn't exist, would the Little Stop and Shop in West Hartford be the closest?
Distance-wise, it might in fact be.
Okay. You don't know which store he went to?
I do not.
Do you recall whether he came back with some meat to cook?
Well, he said he was going to get meat. I mean, we all ate meat, so I assumed he came back with meat.
So when he came back, what did you do?
We were outside, probably cooking on the grill, having a drink, talking.
How would you describe the atmosphere during that dinner?
Positive.
When you say positive, what do you mean?
It was a normal dinner party. I mean, we were talking, laughing, talking about real estate, joking around. I mean, it was just like, it was a normal evening.
Did Mr. Dulos at all talk? Well, what did he talk about?
Objection. Hearsay.
Well,
Your Honor, it's not being offered for the truth.
Well, if the question is what topics came up, we're going to allow that.
What topics? We talked about real estate. We talked about politics. I mean, just a bunch of different topics. I don't remember exactly what was said and like throughout the evening, but it was just a normal evening.
Did he talk about his children?
Yeah. He loves his children. He misses his children.
What was his air or his attitude about things with his children?
He was of the belief that things were getting better as far as the potential custody of his children.
And did he seem happy or sad?
No, that night he seemed happy.
Were people at this, and did anyone else come to dinner that night?
Yes.
Who else came?
Hutch Haynes and his wife, Erin.
And again, was the atmosphere similar when they were there?
Yes.
Were people laughing?
Yes.
Were they eating?
Yes.
Was Fotis known to be a good cook?
Yes.
Did he do the cooking?
He did the cooking.
Did he make a salad?
He made the salad dressing. I don't know if he made the salad, but.
You said French fries. Was there anything particular about Fotis Dulos' French fries?
I'm going to object at this point, Your Honor.
Do you have a special machine to make French fries?
Objection.
Sustained.
Oh, Lord have mercy.
How long were you there that evening at the house?
Probably till around 10:15.
And after were you the last couple to leave, or did the Haynes leave first?
No, the Haynes left first, and then we helped clear all the stuff from the table. I think Beth and Michelle did the dishes, and I think we left shortly after that.
And did you continue to talk with Fotis while you were cleaning up?
I would imagine so, yeah.
Did either he or Michelle disappear for a period of time during this dinner party?
No.
Was the atmosphere the same even at the end, after dinner, after you were cleaning up?
Yes.
Was there anything at all at the time that you could think of that suggested that things were not going well that evening?
In respect to what?
In his attitude or anything? Did he ever act in any kind of surreptitious way or disappear, or get on his phone or anything like that?
No. I mean, he might have got on his phone. That's certainly possible, but there was nothing that jumped out at me, even with the benefit of hindsight, that something was wrong.
You actually were interviewed by the police at some later point, correct?
I was, yes.
You were asked whether, even in hindsight, whether there was anything that seemed off that night, correct?
Correct.
And as you sit here even today, was there anything that you think of that raised any kind of red flag with you that something was off or odd?
That evening, no.
That's what I was thinking.
I'm going to ask you if you know the name of Rania Minutis.
I do know the name, yes.
Who is she?
She's a real estate agent in the Farmington Valley.
Just have a moment.
My kid brought me lunch. Yay.
I forgot to ask you, when you first arrived at the house with Beth, did you see any of Fotis's employees on the property at that time?
On the property, no.
Did you see any before dinner?
Yes, as I said earlier, while we were pulling in before we made a right into Jefferson Crossing, Fotis was leaving, and one of the employees was behind him.
Do you know who Pavel Gumieni is?
I do, yes.
Did you see him at all that evening?
I don't remember, and when I was interviewed, I didn't remember who was behind him. It was either Pavel or Andy, and I couldn't definitively say it was Pavel or it was Andy. It's not something I commit to memory. I just saw them leaving and pulled in.
Were they in separate, when you say behind him, in the same vehicle? Or
no, different vehicle.
This is when they dropped the
I have no further
Tacoma
questions.
off. That was a whole lot of
Good
nothing.
afternoon, sir. How are you?
I'm good, thank you.
I just want to start by actually asking you a couple questions about Jennifer.
Okay.
You talked on direct about meeting her first. I think you lived at the same complex. Is that correct?
That's correct. In Griswold Farms in Canton.
In Canton?
Yeah.
Okay. You actually said on your testimony you remember her walking Petros and Theodore, right? In the stroller?
In the stroller, yeah.
Okay. And did you actually become friends with her first before Fotis?
I did meet her before Fotis, yes, and I probably saw her 3 times while she would come up my street on the cul-de-sac, and I saw her once getting the mail, and I saw her a couple times while I was walking the dog. And we chatted the first time, new to the area, she was very friendly, said, "Hi, I'm Jennifer, these are my 2 boys. We live down the street." And
that started your...
That kind of started it, yeah.
Okay. And you also talked about going to Greece for even the 5th child, the youngest, Cleo Noel, for her christening.
Yeah.
Okay. So you've been a part of the kids for a while. when they were young?
I knew all the kids, yes.
Okay. Would you ever think Jennifer Dulos would have left her children?
No way.
You also talk about Hillary, or
She
Hillard.
never would have left her
Sorry,
children.
Hillard. Yes, and you were grateful to Hillard. I think you said in your testimony, right?
Yeah,
Explain-
I think he was very instrumental in the success of 4 Group.
And Hillard is Jennifer's father.
Jennifer's father,
Okay.
correct.
Can you just explain why you think he was successful in the success of 4 Group?
Because he helped finance a lot of the company. So if there was, in real estate, timing's everything, right?
Mm-hmm.
So there was a builder that had bad times. They had a bunch of lots, and we could buy them from the bank or at a distressed price. But you needed the capital. Like Hilliard gave the company, not us, gave Fotis and 4 Group the money to buy really whatever was needed. And, we would run it by him. He would, look at the numbers, make sure it was a good investment. But if he felt it was warranted, he helped 4 Group out with that on multiple occasions.
And this was over the years, correct?
Over the years, correct.
Okay. So if ever there was something that 4 Group was lacking cash in or wanted a big property, Jennifer's father would help out.
Yes.
Okay. And when he passed, you reached out to Jennifer.
I did, yes.
Okay. Now, I have a couple other questions just about 4 Group. When you were working, correct me if I'm wrong, so you were working for 4 Group, then you wouldn't sign the non-compete, so you were fired, but you still had a relationship with Fotis.
He gave the listings to other agents with the exception of, I believe, one, which was 585. It was either 585 or 80. I'm pretty sure it was 585. So, he kept me on and gave me something while he started, giving out listings to other agents at the time. So
Because you wouldn't sign the non-compete?
I think it was, yes.
Okay. And eventually you came back to work for 4 Group, is that right?
I never came back to work with them. He would then give me more listings. He'd give me some of the listings back.
Now, at some point, and you would get, and I'm probably not saying this correctly, so correct me if I'm wrong here, you would get commissions from selling the houses.
Correct.
And at some point, did Fotis request or mandate out of 4 Group that you would reduce your commission to, I guess, share the love, kind of?
Correct.
And that would also be after the point when Michelle Troconis started working and assisting at 4 Group, doing, I think, marketing.
Mm-hmm.
And do you mean yes?
Yes.
You have to say yes. Sorry, it's
I
recorded.
apologize.
Thank you. So she would work at 4 Group doing taking pictures, marketing the property as well?
I believe so, yes.
Okay. And so she would get paid by 4 Group as part of the employee?
I have no idea how she was paid. I was not there at the time, so I don't know how she was compensated.
But it was definitely, she was doing some marketing as well?
Correct.
Okay, for 4 Group. And you also indicated that she was selling rugs? So she had her own business selling rugs?
I don't know if she had her own business, but I know she had some rugs, and we had seen one, and the whole plan was to come over and look at them.
Okay, and that was on May 23rd of 2019?
Yes, correct.
All right, so you get to, let's talk about the dinner party. You get to Fort Jefferson,
Mhm.
and your plan was to see the rugs first? Were you
See
going
the
to
rugs
purchase
first,
them?
and I believe we did see the rugs first.
Okay, and then you're going to stay for dinner?
For dinner, correct.
I know you talked about this on direct, but are you part of the water ski community pond?
I am not. I've been there. I have skied there, but I am not a water skier by any means. I'm a snow skier and a golfer, but not.
It's not for you?
I just no.
Okay, and so you go there. You did you purchase a rug from Michelle Troconis?
No, we did not.
Okay, and you stayed for dinner, and I think you discussed the fact that Fotis at the time. I just want to make sure I say it correctly. You said he was happy, laughing. It was a jovial environment.
It was,
I would say. Okay, and he was. Would you say optimistic?
I believe so.
On May 23rd. Okay, and when
I
you're
didn't hear his answer out loud.
I said I believe so. Yes.
and at that dinner party it was you and Beth.
Correct.
And Hutch and his wife Erin.
Correct.
Okay. Did you know Hutch Haynes and Erin Haynes?
I had never met Erin, but I had met Hutch a couple times.
Okay. So this party of the 6 of you, it wasn't a regular occurrence.
It was not. No.
Okay. And at what time did you know that Hutch and Erin were coming as well?
I think either when Fotis was leaving Jefferson to go wherever, or after he came back and then said he needed to get more meat for everybody. I think he forgot that we were coming. I don't know what happened, but I had no idea that Hutch and his wife would be there. I don't know if they knew that we were going to be there, but we just rolled with it and had a good night.
You learned that night while you were already there or en route?
Yes, correct.
Okay. All right. And that night, you were socializing, talking with everybody, including Michelle Troconis?
Yes.
Okay. In English?
In English, yes.
Okay. And any part of the discussion that night talk about plans to murder Jennifer the next day?
No.
Any part of that discussion talk about plans to dispose evidence in garbage cans along Albany Avenue?
No.
Any part of that discussion involve plans about using the Toyota Tacoma and cleaning it afterwards?
No.
Okay, that's not something you discuss at a dinner party?
No.
Okay.
I'm going to object that last was argumentative.
Well, it's gratuitous.
Gratuitous.
But that's not essentially a ground on which to object, but the jury knows the difference between a genuine question and questions that are gratuitous. So the court is not going to sustain the objection. The jury knows what it hears.
If I may, Your Honor, I will move on.
What's he doing? Did he not hear?
You may proceed, counsel.
Thank you. Just a couple questions about 80 Mountain Road, Mountain Spring Road. So if you were coming out of Jefferson Crossing and where you met Fotis Dulos coming, you were going up towards Jefferson Crossing? So you're driving up north?
I was on Eli heading north. Yep. Okay. And to make a right into Jefferson Crossing. Yep.
Okay, where would, if you're going up and you take a right into Jefferson Crossing, where would Mountain Spring Road be?
Oh, that would be well behind me.
Behind you?
Yeah, so behind me, and then that intersects Old Mountain Road, and then, no, is that, yeah, Old Mountain Road, and then you'd make a right, and then make a left onto Mountain Spring Road.
Okay, was Fotis Dulos driving in?
He was going in the direction of Mountain Spring Road from Jefferson Crossing, but very close to the entrance of Jefferson Crossing, but he made a left out of Jefferson Crossing towards that direction.
Okay, so you kind of passed like ships passing in the night, is
Yes,
that right?
correct.
Okay. Fotis Dulos didn't tell you he was going to 80 Mountain Spring Road,
No,
did he?
I had no idea where he was going.
No. Okay. And if I can just have one moment.
Yeah, their stories are not like, which I know it's been, you know.
I have nothing further. Thank you, sir.
Thank you.
Almost 5 years.
Redirect.
Yes, you indicated that you didn't know if, you didn't know the Haynes were coming.
Correct.
Was Fotis somebody who, when he made social plans, was kind of like last minute?
Say sometimes yes, sometimes no.
You're kind of spontaneous?
Can be, yes.
Was this a formal or informal dinner that night?
I think it was just informal. It was what it was supposed to be, or what it. And I mean, it was.
Yeah. What was it supposed to be?
It was supposed to be go look at the rugs and then go get some sushi in Avon.
But that didn't happen.
That didn't happen. So it was go look at the rugs and stay at Fort Jefferson and have dinner there.
And who changed the plan?
I think Fotis did. I think Fotis forgot we were coming, and the Haynes. You know, I changed the date originally, so he might have had plans on that Thursday. I didn't ask. He just said, "Oh, the Haynes." And so we were like, "We're going to stay here." We're like, "Okay."
You never did go out for sushi that night?
No.
You were asked a question by Ms. Manning about your opinion on whether Jennifer would ever leave her kids or disappear and leave her kids. Remember that question?
I do.
Did you have an opinion on whether, before she had kids, Jennifer would ever do something like that?
Before she had kids, that she would do something
that
like
she ever disappeared?
Objection.
Well, come on.
What's happening now is this. This witness is now being asked about character evidence of someone who's not a witness. Sustained.
Thank you.
I have no further questions.
Good.
Just briefly, Your Honor, if I may. Sir, counsel asked you about Fotis always being late. I think he used the term spontaneous or always late, and it was kind of impromptu with regards to that dinner party. Do you remember him asking you that just now? And so Fotis had a habit of being late all the time. Is that correct?
That's correct. Yeah.
Okay, I think you called it Fotis time before.
Yeah.
All right. Would it surprise you if he was told to be somewhere at 4:30 and he would show up at 3:30?
If he was told to be somewhere at 4:30 and showed up an hour early?
Yes. Would that surprise you?
Yes, it would.
He showed up early for his kid's visit.
Nothing else.
Correct, you may
Good point.
Thank you.
Good point. Good point. She got that in there. It would be unusual for him to show up early, but yet the day, like the Wednesday visit before his, that Wednesday visit before the Friday that she went missing, he showed up early for the visit, and he went up the driveway, which he's not supposed to do. He's supposed to show up there on time, wait for the chaperone, and then they go up the driveway together. But that's not what he did on Wednesday. So that shows that he was potentially already planning that on Wednesday. So basically all we got out of that witness is that Fotis is kind of a douche. He is greedy. He is controlling. And Jennifer, he said she would never lose or never leave her kids. And that's pretty much it. So good, great witness defense. Good job. I don't know if he hid a witness.
I have another witness about to arrive.
She's not here?
Yes, she is. She's in the hallway.
If he was like maybe looking for cameras, or if he was, I don't really know.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or compounds your perjury? Could you please state your name and spell it?
Sure. Beth Reich, BETHREICH.
All right, so this is the fiance of dude who was just up there.
Good afternoon.
She was also at the dinner party.
Yes.
The name that you just gave us, was that the same name you were using in 2019?
No, my name at that time was my maiden name, Johnson, and I still use that name professionally.
Could you tell us what you do professionally?
Yes, I'm an executive at a medical device company.
Do you have any other side employment as well?
Not side employment. I have side interests. I'm certified as a research coordinator and a domestic violence counselor.
Can you just tell us what your educational background is?
Sure. I studied opera at the Yale School of Music. I attended Quinnipiac University. I began my master's there as I had an accelerated program during my sophomore year. I graduated with a bachelor's, a dual major bachelor's in communication and marketing.
What town do you live in right now?
Avon, Connecticut.
With whom?
Stephen Reich and our collective children.
You have children and he has children?
Yes.
So how many children do you have separately?
I have 2 teenage boys.
And collectively, how many children are there?
3.
Did you know Fotis Dulos in 2000? Well, did you know Fotis Dulos when he was alive?
Yes.
Could you tell us how you met him?
I met both Jennifer and Fotis Dulos in November of 2014 when I went to the offices at Fort Jefferson Crossing, the Ford Group.
Who was living there at that time?
Jennifer, Fotis, and the 5 children.
Did you communicate at the time with Jennifer Dulos?
Yes.
Did Stefan as well?
Yes.
Did you communicate with Fotis at that time?
Yes.
Well, how would you describe your interaction with Jennifer Dulos during that time?
Object, Your Honor.
How would you describe your interaction with Jennifer Dulos at that time?
Okay.
Ground.
Relevance, we're talking about 2014 interaction with Jennifer Dulos, the alleged victim in this case, Your Honor. It's not relevant.
Well, unless the inquiry is going to go beyond 2014, it's not relevant.
I understand. This is a preliminary when they met, and I'm going to then progress. So,
the court will overrule the objection.
Do you want me to describe the moment I met her, or do you want me to describe
no,
the totality
I'm looking for
of my
the
experience?
general demeanor of the interaction.
Friendly, welcoming. She was very happy that Stefan and I were in a relationship, which was brand new in November of 2014. And the relationship expanded and our interactions evolved from there.
After that, did you become aware at some time that Jennifer had moved out?
Yes.
So before she moved out, was there any change in the way you interacted with her in terms of demeanor, what the relationship with you was?
the relationship became less of a slight acquaintance to a much more friendly relationship. We did socialize at dinners. I found her to be extremely supportive during some difficult circumstances and stuff in my collective life. I found her to be very intelligent. One of the first times we had a more intimate conversation when we were alone at the home, she used the term effusive. And as a lover of lexicon, I kind of appreciated that a great deal. So the interactions were always warm and friendly and welcoming.
And did that, when was the last time that you spoke with Jennifer?
I would say perhaps late, maybe very early 2017. I don't recall exactly, but it was certainly not after she left the marital home.
So before she left?
Correct.
Did your children interact and play together as well with her children?
Not on a regular basis. My children all ski. Stefan was a competitive skier. I'm a skier, and all the children skied. The Dulos children skied, and as did Fotis. So we would find each other together on the mountain, and we would ski together when my boys were very young.
So let's be, I want to be clear. We're talking about skiing on a mountain. We're not talking about water skiing.
Correct.
Right. So in addition to water skiing, there was competitive downhill alpine skiing?
Correct.
And the Dulos children were involved in that?
Correct.
And Stefan's son was involved in that?
I don't recall exactly, but we would usually go as a family when the kids were little.
Did you ever meet Michelle Troconis?
I did.
What were the circumstances of you meeting her?
The mistress.
Fotis and Jennifer had left the house. Fotis and Jennifer had begun their, I don't know if it was legal separation at the time, but their separation. And to be blunt, we kind of got Fotis in the divorce, if you want to put it that way, because he was local and he and Stefan still had business dealings. Mm-hmm. And I think our first interaction was we had a sushi dinner together where we were introduced. And I think we were asked to be there for that dinner because Fotis wanted maybe a safe space to introduce Michelle.
How would you describe your meeting with Michelle? How did that go?
Fine. Very engaging, worldly woman. Just getting to know somebody. It was friendly. Do you speak Spanish? Poorly. I did when I was in Barcelona.
How long were you in Barcelona for?
12 days.
12 days?
Yes.
Okay. So you didn't live there for a year?
No. We travel a lot and I try and learn the language for the country that we're going to.
Did you communicate with Michelle in English or in Spanish?
English.
Did you have any difficulty communicating with her in English?
No.
Were there words that she didn't know sometimes?
Nothing that sticks out.
Okay. So in any event,
look,
socialized with...
That goes against everything he keeps saying. That's not the answer he wanted. So every time that happens, he goes, in any event, every single time.
Stefan and Fotis with Michelle?
Correct.
Over what period of time? Over how long a period of time?
From our primary meeting in 2017 until May of 2019.
When you said that you inherited, or whatever word you used, Fotis in the divorce, did you ever talk about his divorce in your presence?
He spoke about judicial matters and some frustrating elements about those judicial matters, but I think he learned very early on that neither Stefan nor I would welcome any negative commentary about Jennifer. So it was really mostly about his experience during the judicial process and his frustrations with it.
I just want to follow up on that. Had you expressed some disapproval of hearing negative things from him about Jennifer?
We never said it outright, but I think if anything was perhaps started or proffered, it was obvious that we weren't interested in engaging any type of communication like that.
Do you recall there was a specific invite to dinner with Fotis and Michelle in May, specifically on May 23rd, 2019?
I do.
What do you recall about the circumstances of that invite occurring? That is, before the dinner itself. Like, how did the invitation get sent out and accepted, if you recall?
I think it was probably just a text request by Fotis to Stefan, and then we attended.
Do you know, or can you tell us whether or not Stefan had a habit with regard to being on time for things?
Stefan is militantly punctual, so yes.
Is that more, the way you said, is more so than yourself?
He's very, very punctual on all matters.
And if the invitation was for a specific time, did you and Stefan arrive on or before that time?
We would have arrived either at the specific time or a couple moments before.
Could you tell us, by the way, do you recall arriving at, or do you recall driving to 4 Jefferson Crossing for that evening, social evening?
I did not drive. Stefan was driving the car, but yes.
Do you recall seeing someone that is Fotis outside the house before you got there?
Yes, as we were pulling into the entrance to Jefferson Crossing, it's gated to a degree. He was pulling out, and we didn't collide, but we were parallel, and we rolled the window down and said, "Hey, where are you going?" And it almost seemed like maybe he had forgotten we were going to be there. And then he said something about an errand and left. And then we proceeded to 4 Jefferson.
Was there anyone else either with him or following him out of the intersection there?
I do recall that there was a vehicle that was following him, but I don't remember exactly who it was or what vehicle it was. I'm not 100% certain.
During the time that you were involved with Stefan earlier on in this relationship, would you spend any time at the 4 Jefferson Crossing offices meeting any of the other employees?
Yes.
Do you recall whether the person that was following was an employee?
It could have been. If I don't know who the person is, I don't exactly remember who it was. I'm
So
sorry.
let me move on from that. When Fotis said that he'd be right back, did he come right back?
I don't exactly remember the length of time, but he was back in due course, a very short period of time.
Can you tell us did you continue on and go into the into 4 Jefferson Crossing?
Yes, after we exchanged communication with Fotis, we pulled Stefan's car through the porte cochere, parked on the French trellis portion of the driveway, and then proceeded into the house.
And just for those of us who don't know French, the porte cochere is the archway that separates the 2 garages on the left from the 2 garages on the right?
It's the archway, yes, the porte cochere.
So when you arrived, did you go right into the house?
I think we went to the door of the mudroom that was adjacent to the kitchen and announced our arrival somehow, and I probably brought something. I don't usually go empty-handed, so it was probably a bottle of wine or something. Put that on the counter, and I think Michelle greeted us in the kitchen.
Do you recall hearing her before seeing her?
Yes, the window was cracked. The window to the right of the door was cracked a little bit, and I heard her kind of speaking to herself.
In what language?
Spanish, I believe.
And when you came into the house, how did she react when she saw you?
Well, she knew we were coming because we were there specifically to see something of hers.
And what was that?
We were going to see some rugs, and she had been carrying them and laying them out. There were some in the TV room adjacent to the kitchen, so it's kind of like pathway from the kitchen to the TV room area. And then there were also some in the offices upstairs. And I imagine they were probably heavy, so she was probably a little flustered, and that might have been what I heard through the window.
Is there a reason you were looking at these rugs at that time?
Yes, I actually have 3 of those types of rugs in my house, but they're cream and silver. And Michelle didn't have that in her inventory at the time, I don't believe. But it was an aesthetic we were interested in.
And were these being laid out for what, so you could look at them?
Yes.
You said some were laid out where were they laid out downstairs?
In the room adjacent to the kitchen. It had very large sectional, a television, and I don't recall any other details about the room.
Did you say you also went up to the office?
We did.
And were there other rugs to look at up there?
Correct.
Were they already spread out for you to look at?
Yes.
Would you describe her demeanor while you were there?
Yeah, she was telling us about the rugs. It was normal. She was happy we were there to see what she was selling for her new business and the support. She explained the details, where they were sourced from, and maybe where she was selling them currently, but I don't recall specifically.
Did you eat there that night?
We did.
Do you remember what you had?
It's a meal often repeated. So it was grilled meats and fresh French fries because they had a French fry maker in the grill outside and a Greek salad.
You say grilled meat. Was that a Greek thing? You said it was a common meal.
What kind of
Yeah, it
grilled
was
meat?
a common meal with Fotis at his home.
But was it steak or chicken?
How would you describe the tenor of that evening in the meal?
Positive, jovial, relaxed.
Did another couple come?
Yes.
Do you remember who that was?
Yes.
Who was that?
Hutch Haynes and his wife. I believe it's Mary Ellen. I haven't seen her since that day.
If her name was maybe Aaron, might that ring a bell?
Thank you.
Yes, that's
Yes,
correct.
thank you.
Okay. And when they arrived, did anything change, or was it the same atmosphere?
No, it was the same atmosphere, just maybe a bit bigger.
Do you recall whether at any point Fotis left the house? You said he came back in due course, was what you said before, right?
Mm-hmm. Yes, yeah. I'm sorry.
Did he leave again to run an errand?
Yes.
Tell us about that, please.
He had prepared or taken some meat out for the dinner and realized that there wasn't enough, perhaps, for everybody, and went to buy some more.
Did he say where he was going?
Not that I recall.
Do you know how long he was gone for? The second time?
I don't know, but probably wasn't that long.
What were the subject? Did people talk during dinner?
Yes.
What did they talk about?
General topics. Hutch has a ski pond he's very passionate about, so we talked about that, obviously. I'd never met them before, so it was an opportunity to learn more about them. We talked travel and politics and current events and interests, the general kind of banter at a dinner.
Did that bottle of wine you mentioned get open?
Oh my God. Yes, and I believe there were a couple more.
All right. Were there any toasts that evening?
Yes.
Could you just describe that?
We learned that evening that, or I should speak for myself. I heard that evening that Fotis had been at Jennifer's home in New Canaan with the children, and that experience and their interpersonal reactions to each other was very amicable, which we were very glad to hear. And he had also stated that the custodial evaluation.
Objection, Your Honor.
Well, any testimony about what Fotis Dulos said about the custodial report or the investigation is not admissible. And follow up, counsel.
So without getting into what the custodial report said, what was the mood regarding the toast? What was the toast about?
Object, Your Honor. This is clearly asking for hearsay.
Well, the preliminary question is, was the toast about what was in the custodial investigation or the custodial report? And then the court can act on the objection. If that's the question you wish to ask, counsel, you may.
Yes. What was the toast?
I don't know any words that were particularly said, but the general sentiment that I recall was a feeling of excitement that there was going to be positive resolution for them both during what I knew to be a very difficult custody battle, which despite which side you're on, it's very, very difficult for either parent and very difficult for the children. And the sentiment was that maybe this was going to end and there would be more peace.
And how did you react? What was your reaction? You happy?
Objection, Your Honor. Relevance.
Relevance, counsel.
Well, the fact that she heard something and reacted to it is the purpose of these.
The jury can draw no probative value from this witness's reaction to what Fotis Dulos said. Sustained.
Was there any negative comments whatsoever said about Jennifer during this time?
No.
Was the entire evening a positive and hopeful evening?
Yes.
Was that true even after you finished the dinner?
Yes.
Was that true after you finished the toast?
Yes.
At any time, did you see Mr. Dulos act in any surreptitious or underhanded manner during that dinner?
No.
Anything that stood out as being odd?
Just that when we drove in, he was driving out and he almost seemed like he had forgotten we were coming.
Okay, but you said that wasn't odd for him.
I don't know if I actually said that, but it's often that in my experience with men, if you're a host of something, you might forget sometimes.
Okay. And how was Michelle's attitude that evening, or demeanor during that dinner?
Engaging, friendly, positive.
At any time, did you see her act in any strange way or leave the room in any surreptitious way?
Not that I recall.
Did she join in the toast?
I don't know how many hands were in the center, but I imagine she did.
Were people laughing?
Oh my God,
I don't
this
exactly
is
recall.
stupid.
Yes.
Oh my God. Oh my God.
Do you recall whether you were the last to leave or whether the Haynes left before you?
The Haynes left before us.
So if you arrived at, what time did you arrive?
5 o'clock.
And what time did you stay until?
I think it was around 10:30.
And you said the Haynes left before you. Do you remember how much sooner?
I don't recall.
Did you, after dinner, did you help with anything?
Yes, Michelle and I cleared the table and worked on the dishes. And I'm not quite sure what Stefan and Fotis were doing.
All right, but did you chat with Michelle while you were doing the dishes?
Yes.
And what was the tenor of that conversation?
Nothing negative.
Hold on. Listen, the cannon's about to go off. See if you can hear it. Did you hear it? I don't know if y'all can hear that or not. Maybe not, because I have all the sound muffling thing. They're going to shoot it one more time. Here it goes. Oh, you can't hear it? Are they going to shoot it again? There it goes. Did you hear it? It's the cannon.
Nothing that would bring me pause.
And was it upbeat?
Yes.
Do you recall, apologize, never mind. Even now, almost 5 years later, is there anything in hindsight that you think was strange or odd during the dinner, during the time that Fotis was present in the house, or Michelle was in the house, that with 2020 hindsight would make you think differently about that dinner?
I'm sorry, can you repeat the question?
Sure. You've described what it was like, how you felt, how it seemed that it was going. Now, 5 years later, with this case going on and all that has been...
Okay, they just shot it a third time, so they're feeling frisky because they're back out there again. Probably because it's so pretty outside today. And it's been cold. So they just shot it again.
In the media since then, is there anything in hindsight that you think was odd about that dinner that you didn't bring up at all?
About that dinner, no.
Yes, or that evening?
No.
I have no further questions.
Right.
Well, do you wish to take the afternoon recess now and cross afterward?
That's probably a good point, Your Honor. Thank you.
Ladies and gentlemen, we will take our afternoon recess. Please do not discuss the case.
All right, now we're pretty much almost caught back up.
Judge, this is actually about another witness, so I don't know if...
This regards another witness?
Yes, I don't know.
To be heard or already testified?
Neither, actually. I just wanted to put something on there. I don't know if the
You
witness
may
could
be
just step
seated.
out for just... Oh, all right.
That's fine.
Quickly. Then the jury's.
Oh, that's right. All right.
Can we approach it sidebar then, Judge? Thank you.
No. Well, oh, we can go through sidebar. Oh, for the sorry, I'm just now seeing the tourist hunting. No, we're not at war and they are not shooting seagulls. So there's a boat that comes by. It's out there right now. It's called Sea Screamer, and it comes by. It's like a tourist boat. And they have them they have multiple of them, but they'll come by all day long. And they haven't been out much. Like they're just now getting back going for the season. So it goes out there and it's like this big yellow boat and they have a cannon. So it's kind of cool because like when you ride on it, it has like all the people that are on there or whatever. And like they have like a little bar and they play music and stuff. And they'll go to over by Shell Island and the dolphins will always chase it, which is kind of cool. But they'll pull up in front of the condo and shoot the cannon. Normally they'll do it twice, but that one did it 3 times. But I've been sitting here before I moved my desk this way, because I moved it this way because I missed seeing the water all the time because now I can see the water. But when I had my desk facing this way and I couldn't see the water, it would scare the shit out of me because I would be sitting here and all of a sudden like we were under attack and so I would jump. But now I can see it coming. But I was curious if y'all could hear it or not. There is also a pirate ship that comes by, but they don't blow the cannon out here in front of us. They do their cannon over by St. Andrews Park.
Here's a question about part of the defense.
Yeah, it looked like she was motioning that she couldn't hear or something. Hold on, let's go back. Here she goes. Here she go. Oh, probably to the translator. Because the translator is up there.
Part of the defense has been that Fotis Dulos was...
The translator has been sitting or standing up beside the witness and talking into little things, so it was probably to the translator.
Telling everyone he knew, including Michelle, how good things were going now that the custody study came out and how optimistic he was. I thought the court's ruling was we couldn't get into the actual custody study. Whether what Dulos said was true or not, it happens to be, because the court is aware, true. But whether it was or not is not the issue. It's the fact he said it, so it's not being offered for the truth. It's being offered to show the reaction that he's telling everyone this. And that's why Michelle, it would negate the idea that she thought that this was going to go on and on and on, despite the fact that at least there was all this optimism being said literally the night before the disappearance. So I just want to put it on the record. The court has not allowed that. I'm going to ask the court to reconsider because it is sort of part and parcel of the defense to be able to elicit what Dulos was telling people about it. It's going to come up at least with one other witness. And so that's why I asked that the court reconsider that restriction.
Well, the gravamen of the offer is that on the 23rd or the 24th, right now it's the 23rd, he was happy about the way things were going. There need not be a mention of the custody report. There's already evidence that he was optimistic about the way things were going. That's been testified to more than once.
I don't disagree. What I'm asking, though, is the court is also precluded to have any witness talk about that. He was at least talking about the proceedings, that how things were going in the court was optimistic. And I would have asked this witness whether they toasted to new beginnings as a result of those statements about the actual court proceedings. Not that he personally felt it, but he believed that the court was going his way. That's the purpose of it.
Well, if that's the offer, there need not be mention of the custody study. Were things going his way in court, according to him? Yes.
According to him.
I thought they objected to even mentioning court, and that's why the court, I thought, precluded that question. I don't have to mention the study at all.
Well, if the question is whether he thought things were going well in court on that date, without reference to the custody study, the court would allow that.
All right.
But any effort to pry open what was happening in court, what was filed in court, other than the court understands that there will be a witness who will discuss what the filings were and when those filings were done. But again, it's really the same question. Was he optimistic about custody with his children? Yes. Was he optimistic about the way things were going in court concerning custody? Yes. It's the same question. Okay. You can bring the jury out, please.
Bring the jury. Dang, we're like pretty much caught up to live now, and that makes me sad.
Thank you. Good afternoon, ma'am. How are you?
Good afternoon.
Just a couple questions I had. I actually just wanted to ask you, counsel asked you if there was anything odd or anything in hindsight about looking back at that dinner party on May 23rd. Mm-hmm. And I want to ask you about your answer. Mm-hmm. You said no, but you clarified that with saying at the dinner party. Was there anything else that you thought was, in hindsight, odd or different?
Oh, good question.
Not at the dinner. Everything I testified with respect to interactions and feelings, et cetera, at the dinner was completely accurate. The question of hindsight in this case, how it is relevant to that statement is after the warrants came out and all the circumstantial evidence came out pertaining to Fotis, it seemed as though perhaps
I have to object. If after he was arrested, she has an opinion based on what she read about, I would argue it's outside the scope of direct irrelevant.
Well, the court understands the testimony to be hindsight testimony. Overruled.
You can continue, ma'am.
But, Your Honor, the hindsight had to do with the dinner, not about now 5 years later what she thinks.
Your Honor, he specifically asked her in hindsight sitting here today. I'm just asking what she meant by her statement, and she has a right to answer that.
Well, the question is not whether the witness has a right to answer. The question is whether the question is admissible. The issue of hindsight has come up, and the court is not necessarily convinced that hindsight referred only back to the dinner. So, in other words, the court does not recall whether hindsight referred just to the dinner on May 23rd or hindsight referred to anything.
Well, I asked the court then to review the testimony because that was the question, and that's what I asked about even now. Was there anything about the dinner that evening that was odd or in any way?
Well, because this is the problem that arises. Hindsight about anything, just at any time, is not going to be admissible. Hindsight about May 23rd will be admissible. So the court's understanding is, the limitation that is looking back now, is there anything about what was done on the 23rd, anything you noticed that you're now thinking about that you didn't think about on the 23rd of May, 2019?
I want to hear it.
Because what the court wants to avoid is this. Looking back now after you've read media reports, watched media reports, is there anything about Fotis Dulos now that you're thinking about in hindsight that essentially you didn't think about that on May 23rd? And the reference could refer to something Fotis Dulos did back in 2014 or 2016. So the court, in fairness, wants to limit that testimony because it may be unfairly prejudicial to tag any particular time in the acquaintance between Ms. Reich and Fotis Dulos. So if it concerns May 23rd, 2019, the court will allow the question.
Thank you, ma'am. With respect to May 23rd, 2019, is there anything in hindsight that you thought was different or odd?
In hindsight, what sticks out to me is the dichotomy of the positivity of that evening.
Bam.
And what subsequently occurred. And again, with the benefit of hindsight 5 years later and continuing to process that concept, that dichotomy becomes more pronounced.
That's exactly what we said.
This was the first time you had met Michelle Troconis?
No.
No. When did you first meet Michelle Troconis?
In 2017.
And you had gone out to dinners with them?
Correct.
And you had gone eaten at 4 Jefferson Crossing?
Correct.
It's the first time you met the Hayneses. Is that right?
May 23rd, 2019 was the first time, yes.
Okay. And that night there was the toast, and the toast I think you testified was because things were going to end. Was your testimony, is that right?
I believe I testified to the fact that there was going to be a positive resolution for both parents, and much of the negativity that affected all parties, the children and the parents, and the extension of the family would end. That was the purpose of my statement.
Okay. All right. Thank you very much.
Bam!
I just have a few questions. When you talked about
Of
the
course you
positive
do.
resolution that you were talking about on May 23rd, 2019, was that specifically upbeat about how things were going in court, according to Mr. Dulos?
According to Mr. Dulos?
Yes.
Yes.
And was it optimistic from Mr. Dulos about how the things were going into the future, that he would be spending more time with his children?
Correct.
No further questions.
1 second, Your Honor, if I may. Nothing further. Thank you.
Ms. Reich, you may step down.
Thank you, Your Honor.
Bam. Okay, so that's exactly what we said too. Because remember, I said something about how hearing how he was so positive that night, the night before Jennifer, was killed. He's so positive about like, oh, I'm about to get more time with my kids, and and now they're talking about like, oh, cheers to me having my kids more often, and then bam, the next day Jennifer's gone. She says now, looking back, the dichotomy of the positivity of that night and how normally everything was so negative and everything was so bad and terrible, and the divorce was so bad and the custody was so bad and everything's so bad, and then all of a sudden like rain, it's raining unicorns and sunshine and shit and stuff, sorry, and everything's all sunshine and roses, and they're cheersing and making toast and all this stuff to how he's going to have his kids more, and then the next day Jennifer, who has custody of the kids, disappears. So to her, looking back, she's like, okay, the very first time you're ever excited and saying you're going to have more time with the kids, the very next day their mother goes missing. Like, that's one of those things that you know. It's like all of a sudden now he's saying he's going to get time with the kids, and then she goes missing. So they could look at that, the jury can look at that as, and I'm assuming that's the way she makes it sound is the way she looks at it now too, that it's a possibility that he's saying all this stuff about how he's going to get the kids more often now because he planned on getting rid of Jennifer the next day. So yeah, who said this? Yeah, 0 for 3 on the effective witnesses for the defense. 0 for 3.
Please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or competency of perjury? Yes, I do. Please state your name and spell it for the record. I'm sorry, what? Say your name and spell it for the record.
Cheryl Briere, Cheryl. B as in boy, R-I-E-R-E.
B what? Hold on, Cheryl. Speak up a little bit, babe.
Cheryl. B as in boy, R-I-E-R-E.
I don't know if I spelled that right. Cheryl.
Good afternoon, Ms. Briere.
Softly.
Would you please indicate to the members of the jury what your profession is?
I'm a hairstylist.
How long have you been a hairstylist?
25 years.
Could you tell the jury where you practice your trade, your profession?
In Avon, Connecticut.
Where do you live, by the way?
Granby, Connecticut.
Do you know Michelle Troconis?
Yes, I do.
Could you tell her how you met Ms. Troconis?
I was working at a salon on 44, and she came in and wanting her hair done, and I just happened to be the girl sitting at the front desk.
Oh,
so we just started
tell all the
chit-chatting,
tea.
and I said, well, why don't I book you with me? And she came in a couple days later, I guess, and I started doing her hair then.
When you say 44, you're
Route
referring
44,
to Route
sorry.
44?
Route 44, Avon.
And does Route 44 have another name in Avon?
Main Street?
Albany Avenue?
Albany
maybe?
Avenue, yes.
Okay.
Yes.
And you were a hairdresser. What year was that? Do you remember?
That I started doing hairdressing?
No, that you met
that
Michelle.
I met Michelle? 2018.
Do you recall over the course of the next couple of years, how often did Michelle come into the shop to get her hair done?
Probably every 3 to 5 weeks.
Did she usually book with you
Yes, always.
as her hair stylist?
Yes, always.
Do you recall whether you saw Michelle during the week of May 20th, 2019? That is the week before Memorial Day weekend.
I can't specifically say to the date, but I think she was in on a Saturday to get her hair done.
Do Do you recall reading or learning something about the disappearance of Jennifer Dulos, the wife of Fotis Dulos?
I found out on the news when everybody else found out on the news.
Before you found out about it, did you see Michelle Troconis that
Yes,
Saturday?
I did. Yes.
So would it
So
have
I'm
been?
going to say like maybe a week before I found out I had done Michelle's hair.
All right. So what do you, if the day that, do you know when you found out?
It was like a week later when it came out on the news. So I'm going to say week and a half later.
All right. And this was, you're saying a week before that you saw Michelle?
Yes.
If I were to tell you, just to orient the time, that the allegation was she disappeared on May 24th, 2019 on a Friday, what day would you have seen Michelle?
Saturday.
The next day?
Yes.
Would you just, how many times would you say over the previous 2 years had you met with Michelle?
The last 2 years?
Before
that. Like to have her hair done every 3 to 5 weeks. We became friends. We did some small business things along the way to promote women in small business.
What kind of business? Did you have any business interaction with Michelle
Yes.
during that time?
One of them was she sold rugs. We put her rugs in our salon. I bought several rugs. I have a little side business without wine. So we had a little wine tasting at another friend of ours' shop.
Did she have split ends?
Just promoting small women in business.
That Saturday, what was the reason that you were in contact with her?
She came to get her hair done.
Did you, in fact, cut her hair that day or
Yes.
trim her hair, whatever,
Yes.
style her hair?
Colored her hair, yes.
Okay. And would you describe her demeanor and how she was on that occasion?
Michelle is always happy. She's just a positive person. I never see her mad or anything like that. She's just always uplifting. She lifts other people up.
Let's talk about May 25th, 2019.
Okay.
That day.
Okay.
Was there anything unusual about her behavior that day?
No.
Do you recall what you were talking about with her, subject matter?
Your Honor, I'm going to object at this point. Relevance, hearsay.
Well, the defendant's demeanor one day after Jennifer Dulos was missing is relevant.
I noticed
The
that.
topics that came up are also relevant, but the court is not going to allow testimony into the substance of the topic. So overruled.
Ms. Breer, do you understand the difference? But I'm asking you
Personally, I would like to hear more about the wine tastings.
to say what she said, just what topics you were talking about.
We always talked about family and the kids. What are you doing this weekend? That type of thing.
Was she, at this point, happy or sad
No, she was always happy. She was happy.
on that day?
Yeah. Yep.
Do you know what time her appointment was with you?
Dad, I can't.
Was it in the morning?
Honestly, I can't say.
All right, thank you.
I mean, if you want to.
Okay, so now witness number 4, he brings in, and she just testifies that the day after she found out that her boyfriend's wife is missing, she comes in all happy. I don't think that's the flex he thought it was going to be. Like, I don't think his witnesses are hitting how he exactly thought they would.
I know my hours. I could tell you my hours were 9 to 1, if that helps.
Oh, so on Saturday?
So on Saturday, I do work 9 to 1. So she was in that time frame, if that helps you.
Right. And when you say till 1, do you take an appointment at 1, or is that when you leave?
I would take an appointment at 1.
So you don't know whether it was 9, 10, 11?
No, I don't recollect.
All right. I have no further questions.
Briefly, if I can.
I'm sorry, what?
Hi, ma'am. How are you? I'm Michelle Manning. I represent the state. We've never met, right?
No.
Okay. Actually, just a couple questions. So that Saturday would have been about Saturday Memorial Day weekend would have been about 5/25, 2019.
Yes.
Does that date sound right?
Yes, that sounds right.
Okay. And you worked between like 9 and 1?
Yes.
Ish. Okay. And Michelle Troconis came in to get her hair cut. That was your testimony? Or hair colored?
Yes.
Okay. And she was happy?
Yes.
Okay. Nothing further. Thank you.
Nothing else.
We already may step down.
Thank you.
So far, let's
Thank you.
let's summarize this a little bit. So far, his witnesses have told us that Fotis is a jerk, and he's greedy, and he's controlling. Jennifer Dulos would never leave her children. Fotis had all of a sudden started, like the night before, started talking about how he's about to have his kids a whole lot more now that they're gone, and then the next day his wife is gone, and knowing that she's missing, Michelle goes in and gets her hair did and is super happy. So that's where we're at so far with the defense's case. Okay. All right. Got it. Got it. Whoa. Easy on the microphones, fellas.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
Jeffrey Glad, Jeffrey Glaue.
And you may be seated.
Good afternoon, sir. Would you please indicate to the members of the jury where you are employed?
I am a Farmington police officer in the town of Farmington.
In where?
In the town of Farmington.
Could you tell the jury how long you've been an officer with Farmington?
I've been an officer in Farmington since 2009. I left. I have to think this through, but technically just made 11 years.
During that time, you just indicate what positions have you held with the Farmington Police Department?
I started out as a regular police officer. I was assigned to the mall for a period of time, and the last 4 years I've been assigned as the evidence officer.
So
liaison.
We're down here in Fairfield County. When you say the mall, would you just indicate to the jury about the West
So
Farms?
Farmington has a substantial mall called the West Farms Mall. Part of it's in West Hartford, but most of it's actually in the town of Farmington. It tends to be our busiest area in the town.
After you were assigned there, what other positions did you hold?
Nothing substantial there. I mean, in Farmington, just for the time that I've been there, it was the officer, West Farms Mall, and now the court liaison officer.
And as the court liaison officer, are you also the individual who acts as the evidence officer for the town of Farmington?
Yes.
Could you just indicate to the jury, what does the evidence officer, let me rephrase the question. What is the evidence officer's responsibilities in the town of Farmington?
I'm responsible for logging in and logging out all evidence found property and tracking that, making sure court forms are filled out, moving those forms and evidence back and forth between court and various locations and keeping track of that.
Are you also responsible for receiving evidence from other law enforcement agencies?
Yes. So receiving evidence is in totality for wherever it's being generated. If it's being deposited with the police department, I'm responsible for it.
Were you subpoenaed to come here today?
Yes, I was.
Were you asked to bring something in particular?
Yes, I was.
Would you please indicate to the jury what it is that you were asked to bring?
Your Honor, this is a point that state's objecting.
The issue of what you were asked to bring is not probative. So the court's going to sustain that objection.
Did you bring a document with you today, an envelope?
Yes, I did.
Is it sealed?
Yes, it is.
Could you just tell us where you received this from?
From the Connecticut State Police.
And is there a document that indicates that you received it from the state police that acknowledges your receipt of this document?
Your Honor, I'm objecting if I can at this time.
Well, the issue is whether these questions are probative. Did you receive a document from the state police indicating that they sent you a document? The court does not see the probative value of this series of questions. So sustain.
May I see the document that you brought with you today?
And this is the envelope that the document's inside.
All right, I'm going to ask that this be marked for identification.
Well, any document can be marked for identification.
Could you just tell the jury, when did you receive this envelope?
Well, by my time period, so my property evidence label on it is listing that on May 13th, 2020 is when I logged it in as evidence.
Who did you receive it from?
I don't remember exactly the person, but it was a Connecticut State Police crimes detective.
Without actually stating the name right now, is the name of the individual indicated on the outside of that envelope?
Yes.
Did that envelope come from the Western District Major Crime Squad?
I believe it did.
Was it in connection with the case of the disappearance of Jennifer Dulos?
It was in connection with Mr. Dulos' suicide.
and showing you what has been marked as Exhibit PP for identification. Can you just tell the jury what that document is?
This is a receipt that I signed by the state police for the various items that they turned over to me as part of their processing the scene for the suicide or death of the deceased.
Does that receipt include the whatever is that envelope that you're also holding, which is double Q?
Yes, Exhibit 0390 is listed on this, and it's what their case number or tracking number for evidence listed.
You said 0390. What number?
It's listed as Exhibit 0390, handwritten note, and that's what their exhibit number also relates to the tag that's on the envelope.
Right. Your Honor, I'm going to ask the witness to open. I'm not going to offer it through this witness. There has to be additional foundation laying, but I'm going to ask that the witness open the envelope so that the chain of custody remains in place. May I do that?
Well, is there going to be a challenge to the chain of custody?
There's not to the chain of custody at all, Your Honor, to the relevance and hearsay nature of this, but not to the chain of custody.
Well, this witness is not going to testify concerning content. So
they ended the feed for the day for Adam Montgomery.
There's no objection to chain of custody. The envelope need not be open.
Oh.
There's not going to be a challenge to the chain of custody.
Okay. In any event, then I'm going to ask that the envelope remain as an exhibit for identification through this witness. And I do offer exhibit QQ. Let me just make sure I'm talking about the right one. I'm sorry, I'm offering exhibit PP, which is the receipt showing this witness's signature and receipt of that document.
Well, there's more on that document than just information concerning the receipt. So the document should be shown to the state.
I gave a copy.
You did, Your Honor, and I'm objecting to this coming in as an exhibit. It's, as Your Honor has indicated, there's more than what is in counsel is offering. I also don't see the relevance of it. It's also a hearsay police report statement. The witness has already testified as to its nature. I would object to it coming in.
Well, it's a receipt indicating that this witness received a document from the state police. But it's more than just a receipt. It just says more than state police sent this document on this date and it was received by the Farmington police. It says more than that. So the court is going to sustain the objection.
Well, it does indicate what is in the contents of that exhibit.
Well, that's the concern, counsel.
Oops. I was trying to move that. Stop pressing buttons, Brandi. Oh my gosh. Every time I try to move the... There we go.
I have no further questions of this witness.
Nothing further.
Officer, you may step down.
Thank you.
I know. I won't press any more buttons.
Please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Please state your name and spell it for the record.
It's Sergeant Sean, S-E-A-N, Bailey, B-A-I-L-E-Y.
Sergeant, you may be seated.
Good afternoon, sir. Would you please tell the ladies and gentlemen of the jury where you're currently employed?
The Farmington Police Department.
How long have you been employed there?
19 years.
What is your current position at the department? What are you responsible for?
I'm a patrol supervisor on the day shift.
Over the course of your career, were you a police officer anywhere before you were a police officer in Farmington?
Yes, I was a police officer in Manchester, Connecticut.
As a police officer in Farmington, could you just tell us generally what was your assignment in January of 2020?
In January of 2020, I was
Your Honor, I'm going to
the,
object. Relevance.
Well, this was a matter that was preliminarily discussed outside of the presence of the jury. So what the court is going to do at this point, ladies and gentlemen, the court is going to take up legal arguments on a matter. And we'd ask you to just retire to the deliberation room while the court does that.
All right, we're live now, so I can't fast forward anymore. Oh, no.
So essentially, court understands this testimony to concern a document allegedly authored by Fotis Dulos,
All right, suicide note.
commonly referred to as a suicide note. Is that what this testimony is?
No, Your Honor. This witness is the one who was called to the house because Mr. Dulos was apparently missing from where he was supposed to be. He observed somebody in a vehicle. He observed Mr. Dulos in the vehicle with committing suicide with the hose, vacuum hose attached to the car. He pulled him out with another officer. He called the emergency rescue crew. He was present when at that time, I'll just note that that's when the note was seized. It then went to the state police. It was Detective Kimball who called this witness to go to the house. And in fact, and they found Mr. Dulos there. So the main import of this, even if the court does not end up allowing in the suicide note, which I'll note is marked as 0390 on that receipt, that the circumstances surrounding it, surrounding the fact that Mr. Dulos is unavailable is the thrust of this testimony. I would not be asking this witness. I do have one more who actually is the state police individual who actually seized the note and put it in that envelope. He's here as well as the name of the officers on the envelope. Maybe we don't need him. He's the state police detective from the major Western District Major Crime Squad. But if there's no objection as to chain of custody, it may not be necessary. I'll just note he's here. That's Detective Barbero. So this is to get to the background about why Mr. Dulos is unavailable. And I'm going to at least try to make the argument that the court then should allow in the suicide note under the residual hearsay exception. But we would have to get into the background, which I believe separately is admissible, before that note would come in. In other words, I wasn't going to offer it through this witness if there was going to remain an objection.
But death certificate is self-authenticating. That's grounds for anyone to conclude that the witness or Fotis Dulos is unavailable. So the court sees no reason for this testimony.
The witness will also testify that Anna Curry was present at the time. He spoke with her, the other occupant of the house at the time. I would not even get into what she told him, but it would be to indicate who that individual was. There was testimony from Detective Kimball yesterday about that, and it was in the video. So
the date and manner of Fotis Dulos' death is not relevant. The court, if there was evidence of a death certificate for counsel's purposes to show that Fotis Dulos is unavailable, the court may consider admission of a death certificate. But date and manner and who was present is not relevant. He's unavailable based on the death certificate.
Okay, so they're wanting to, he says they're wanting to do this to show why, Fotis is unavailable. But the judge is absolutely right. Obviously, like a death certificate would show why he's unavailable. But keep in mind, that suicide note said something about how he was going to, he was doing this because he couldn't stand to spend one more day in jail for something he didn't do or something like that. So I think that Shoehorn is possibly hoping that that will appeal to the emotional side of the jurors, because if they hear like, oh my gosh, you know, like, and look, I'm not saying they would, but I think that Shoehorn and defense is probably hoping if they hear that, they're like, oh, you know, he said he didn't do it, like that, you know, he couldn't possibly spend another day in jail for something he didn't do. And, you know, he felt so strongly about it that he offed himself in the garage and never told anybody where the body was. You know, maybe he's like, if they hear that, then it will have, you know, it'll be good for his defense. But again, that has, I mean, that it's just not.
Does the state wish to be heard?
Yes, Your Honor. As I have indicated, the state feels.
And also, he said, they said that this is exculpatory for Michelle, that note.
Any, as Your Honor said, anything that has to do with the actual manner and cause of circumstances surrounding the suicide is not relevant. The state's concerned with respect to the suicide note, Your Honor, and the use of the note as a under the residual exception to the hearsay requirement, if I may be heard on that.
So that hasn't been offered yet.
That hasn't been offered. So that's really the crux of the matter, Your Honor.
So the court sees no reason for testimony if the state is willing to accept that there's a death certificate. On the death certificate is the date of death. That's self-authenticated.
Yes.
Well, the second argument I would be making is, although I concede that the Connecticut rule of evidence limits dying declarations in a prosecution side to dying declarations.
One other thing too, he does say in there that Kent and Michelle don't have anything to do with it. So that's why they're saying it's exculpatory.
Declarations concerning the victims of a crime, I would make the argument under Chambers versus Mississippi that it's unduly restrictive when the defense wishes to offer a dying declaration, which otherwise would be considered have evidence of reliability because it not only was written and found with Mr. Dulos, but refers specifically to the fact that because of the charges he is going to, he's taking this action. So the timing is relevant to that argument, as well as the question of whether or not it needs to come under the residual hearsay exception. The jury at least need to know that it was that the death was under the circumstances time-wise that it would be material and relevant for the defense. That's my point.
Hold on, let me pull it up. Let's read it real quick.
The state, as the court understands it, would not object to the admission of a death certificate. Now, the residual exception to the hearsay rule, first, counsel, the court believes, is correct in that the dying declaration exception refers to the dying declaration of the victim. So, in actuality, unavailability would not even apply in this case. However, the court sees the progression of counsel's argument. Secondly, even if the court were to consider the residual exception, the court would use as guidance the dying declaration exception. But the dying declaration exception requires, there has to be indicia of reliability. And so the dying declaration exception requires that the statement had to be so far against penal interest. Let's just use that example. If this were not the defendant in the case, that a person in the declarant's position would not have said it unless he or she believed it to be true. Well, first, if the court is to use that as guidance, the court cannot see, based on the facts of this case, that there's a statement against penal interest, because there's no indication.
I can't make that argument, I'll be quite frank, Your Honor. It was not against Mr. Dulos' penal interests.
Not against his penal interest.
No, but there are other indicia of reliability, and I would have elicited that. I'll just state for the record.
Hold on, let's read it real quick. I got it pulled back up. Let's read it so we can know what they're arguing about, because he does say something in there. This is why Shoehorn made the argument that this is why they want it in there so bad. This is why Shoehorn wants it in there so bad, because he mentions Michelle in it. And Kent. Let me see. Okay. Here we go. Let's see. Okay, all. If you are reading this, I am no more. I refuse to spend even an hour more in jail for something I had nothing to do with. Enough is enough. If it takes my head to end this, so be it. I want it to be known that Michelle Troconis had nothing to do with Jennifer's disappearance, and neither did Kent Mahoney. I ask the state to let them free of any such accusations. I also ask the state to stop harassing my friends, Andreas, I'm not even going to attempt that last name, and Anna Curry. So Andreas is the one who called the alibi call from that morning. He's the one who called, and then Anna Curry was the new girl. They are honorable people. Please let my children know that I love them. I won't do anything. I won't do anything to be with them, but unfortunately, we all have our limits. The state will not rest until I rot in jail. My attorney can explain what happened with the bags on Albany Avenue. By the way, the attorney that he had who was going to explain what happened with the bags on Albany Avenue tried to say that somebody dropped those bags off on Fotis's porch, and he had to get rid of it all because he thought he was being framed. Psh, okay. Everything else is a story fabricated by law enforcement. I want to thank all of my family and friends that stood by me during this difficult time, I guess, stood by me this difficult time. Above all, Anna Curry, I am sorry for letting you down and not continuing the fight. So that is the suicide note that they are fighting about right now.
Here, this witness, the department received a call. I believe he received a call from Detective Kimball saying that Mr. Fotis was supposed to be in court at that time, and it was shown that he had not left his home. He was sent there for those purposes, only to discover that he was in a running vehicle with the garage door closed, the lights were on. He broke the window together with another officer. They pulled him out, and so the indicia of reliability and the fact that the note was taken on that date goes more to the fact that it was related to the fact that he believed he was going to jail. So in a way, it's literally against his penal interests, although the statement itself exonerates my client. So that's why I'm arguing it as not as a dying declaration, but instead as a residual hearsay, or under a Sixth Amendment right to present a defense exception, which Connecticut has not yet acknowledged.
Well, again, the court understands, believes counsel's argument. The fact that the statement does not include an admission militates against a finding of trustworthiness. Even if it included an admission, there's no using the guidance of the code concerning statements against penal interest. There's no indication that Fotis Dulos intended to be alive for prosecution. So it could not have been a statement against penal interest, because the code contemplates the declarant being alive to face prosecution. He did not intend to face prosecution. So it would not even be a statement against penal interest. It's essentially an effort that counsel may argue is memorialized and trustworthy, but the court sees that it doesn't meet the measure of trustworthiness. There's no admission, and he didn't intend to go to prison. The court wouldn't allow the statement.
All right. In any event, is the court also precluding from the
In
defense
any
putting
event.
on the circumstances surrounding the death?
Yes, that's precluded.
Well, then I don't have any other questions of this witness.
The jury can come back out.
Yeah, then I'm also going to release the Detective Barbero since there would be no need for him to testify about taking the exhibit and delivering it to the Farmington Police Department.
Thank you.
And then I will offer the death certificate as an exhibit.
Will the counsel stipulate, please?
Yes, Your Honor.
Yes. I just have one question. Did you become aware at some point that Mr. Dulos had died?
Yes.
Your Honor, I'm going to mark this.
I have no objection.
And what's the
RR?
RR admitted as full.
I tweeted it if you wanted to read. If you want to read it, I just put it on Twitter.
Yeah.
Something happened. It was on now. Oh, it's on my phone. Oh, okay. Thank you.
There's a bottom focus button.
Got it. Thank you. And you knew that Mr. Dulos actually died in New York, not in Connecticut.
Yes.
Right. And this is Exhibit RR. It's a copy of the death certificate showing that that Mr. Dulos died on the 30th of January of 2020 in Bronx, New York. Signed by the medical examiner of the city of New York. I have no further questions. Thank you.
I have nothing, Your Honor.
Sergeant, you may step down.
Your Honor, I don't have any other witnesses ready for today.
Thank you. Will a witness be ready tomorrow at 10 o'clock?
Yes.
Ladies and gentlemen, that concludes today's session. Please do not discuss the case. Please regard no media reports about the case, and we plan to see you tomorrow morning at 10 o'clock.
Oh, dang. After his, they took him to the hospital. He didn't die right away. They got there and they took him to the hospital. He was in the hospital for 2 days before he died. So that's why he was in New York, because he didn't die right away. So, crazy day. Crazy day in court. Tomorrow, like, okay, can we all just agree that not even one of his witnesses went the way he wanted it to? That didn't go well. Yeah, did Fotis seriously think because he wrote in a note Michelle isn't guilty that law enforcement would be like, oh, okay, well, we'll just let her off because the note says that she's not involved? Yeah, see, that was the thing that was their whole discussion about that they were having about the merit of it, because you can't just admit it as evidence or a dying declaration, like just because he had it in the car when he tried to off himself. There's like, that's what they were arguing about, was like the limits that they have and like the rules that they have about it. So I was curious if it was going to get let in or not. But him saying, you know, that they weren't involved, that nobody was involved. Okay, if you're saying you weren't either, how do you know? If you don't know what happened, how you know what they did? But whatever. I think that the evidence against Fotis is overwhelming. I think that there's no question about any of that. My question still remains, did the state prove that Michelle knew beforehand? Not did she know beforehand, because I think she did, personally. But did the state prove beyond a reasonable doubt that she knew beforehand and conspired with him against it or for it? Marie Moss with our stats. Witnesses, 7. No sidebars today. I thought we had one. I guess I missed it. Maybe I'm getting my days mixed up. Marie Moss would know better than me. Objections, 32. In any event, 2. So then 2 times he was wrong. Defense witnesses 0 for 6, and 1 precious witness, Jennifer's mom. She was precious. She was precious. Thank you, Marie Moss. You the best. You the best. So here's my question to y'all. If you think that they proved, not do you think that she knew, do you think that they proved beyond a reasonable doubt, like there is no other reasonable conclusion that you can come to, anything else would be totally unreasonable, that she knew and conspired with him against, like, for this? Because I'll be honest, I don't. And I know like 50% of y'all said in that poll that we did, 50% said that you think that she knew beforehand and that the state proved it. I agree that I think she knew beforehand. I do not personally believe that the state proved it. And I'll tell you why. All of the reasons that are listed, and this is just my opinion. I'm just one juror. Thank you for the super chat, Nancy D. Oh yeah, they moved him. He did the hyperbaric oxygen chamber, like the same thing that I have to do 5 days a week right now for cancer shit. PET scan shit. Whatever. Health stuff. He had to do that. They had him doing that too. But he made it for 2 days. How can you believe she knew beforehand and without proof? That's not logical. It is logical. Because, I'll explain. Because I believe she knew beforehand, but do I think that they proved it? No. Those, you don't have to have, you can have one without the other. I think she knew, and there is evidence to lead me to believe that she knew, but I think that it's like if you have to have, you know, like there's enough evidence to make me believe a certain thing, but there's not enough evidence to make me believe that that is the only thing. Like there's enough evidence to make me believe that she knew, but there's not enough evidence to make me believe that the only reasonable like answer is that she knew. I still think that there's no chance in hell that she doesn't get convicted for like the, you know, the after the fact stuff, the cleanup and La Torre de trash cans and all of that stuff. But I think everything else. Who you growling at? Ain't nobody scared of you. You got a ponytail. Where'd you go? I think everything else could be like I believe that the alibi scripts were written after. And the reason I believe they were written after is because of certain things, like going to take the purse and all of that. That's stuff that she didn't know she didn't know that somebody was going to leave their purse there that night. So that alibi script would have had to have been written after the fact. So I believe that the alibi scripts were written after because of that. So that is an after the fact. Speaking of which, Mildred, thank you for the super chat. Alibi notes prove she knew. See, and that's what I was just saying. I personally, for me, I disagree because I believe the alibi script was written after. So, because of some of the stuff that was on there. They did not prove conspiracy. Tampering with evidence, I could see 100% tampering with evidence. Like all of the lies and everything that she told, and look, defense can try to spin that all they want to and say, oh, she was just mistaken. No, we know a lie when we see one. And the way she changed her story so much and stuff, like her pants were on fire for sure. So all of the after the fact stuff, there's not a doubt in my mind. That has been proven, and that horse is dead and gone and has still been beaten. Valerie Frank, if she didn't know, why would she help with cleanup? She said that she was thinking of leaving him. See, think about it like this. What if he did this and then told her, like, came back and was like, hey, I've solved our problem. She's gone. Now we just have to get rid of this. And we have to write down this, alibi script. You need to stick to this. He was sending her back and forth to the house and back and forth to workhouse or whatever. And, they spent the whole day getting rid of evidence and doing all of this stuff. But is it unreasonable, like to the point where you don't think it could happen, that he did it without her knowing and then showed up at 12:22 back at the workhouse, rode his bike back to the house? She said that she heard him calling her down the steps. They had lunch together, whatever. When he got there, if she came down and he was like, hey, I just did this. I took care of our problem. Now you don't have to leave me. Now we don't have to worry about this. Now we're going to have the kids more, all of this stuff. And I need, now we have to get rid of it. And she, has this controlling dude that, is kind of a douche. And now she's like panics or whatever and helps him. That's reasonable to me. And because that's reasonable, I wouldn't be able to convict her, because her knowing and conspiring is not the only reasonable explanation, if that makes sense. Shunga says, once she did that, even finding out after and helping still constitutes a conspiracy. But the conspiracy to commit murder is what it wouldn't fall under the conspiracy to commit murder. It would fall under conspiracy because it would be I can't remember exactly how it's worded. We pulled it up before, but where you're making the conscious choice to partake in criminal activity, which would be for everything else, but it wouldn't be conspiracy for murder, because if Jennifer was murdered before she knew that it was going to happen, it wouldn't be conspiracy for murder. Her raised mom said, I would be afraid Fotis would do the same to her if she ever crossed him. You know, her family is so adamant. If you've ever seen them in interviews and stuff, and even on Twitter and, you know, wherever else, her family is so adamant that, you know, she's innocent. She's innocent. She would never do this. So even like, because my first thought would be, okay, well, after Fotis is dead, then you could come clean and say, you know, I was scared of him. This is what happened. And obviously she didn't do that. But I can also see, on the other hand, having, you know, this family who's like, you know, so supportive of you and going everywhere on every show that will have them talking about how, you know, she's innocent. I could understand her wanting to stick to her story too. I mean, I can understand the thought process behind it, I should say. No alternate explanation was given. You can't make up scenarios not put forth by evidence. But of course you can, because saying that I'm not saying that like you can put it in there like, you know, hey, this may have been what happened, because that's not what they presented. But my point is, if there's not enough evidence to prove that what happened is the only logical thing that could have happened, or the only reasonable thing that could have happened, but you can come up with 100 other, or even one other reasonable explanations to it, to what happened, then that's reasonable doubt. If you can find any one other scenario that could explain it that's reasonable, that's reasonable doubt. A lot of this is going to come down to the jury instructions too. Then why lie about the phone call? She answered, why lie if Fotis was home or not? Look, I agree. She lied nonstop. But however much she lied, her lying about things doesn't prove guilt beforehand. So that's the thing that I think is going to be the most important. Like, okay, do me a favor, for all of y'all that are like super convinced that the state proved it. Take what you believe and what you believe about human behavior and how she should have done this or shouldn't have done that or whatever. Take all of that stuff out of it and just look at evidence presented. If you just look at evidence presented, I don't think the state proved their case. Do I think she knew? Hell yeah, I think she knew. But I don't think that the state proved their case. I wouldn't convict her of conspiracy, because as much as I do think she knew ahead of time, and I want justice for Jennifer, going by the law, I wouldn't be able to convict her on that, you know, based on what we pulled the other day for the specifications of the charges. For her evidence, you have to believe her story brought forth by the defense. But not by law, though. You don't have to believe what she said. You just have to, because it's not about her. It's not about her story. The conviction, that's why defense doesn't even have to present a story. They don't have to do anything. You don't have to believe anything they say, because they don't even have to tell you anything. Convictions are based on if the state proved it, not anything that the defense is giving you to believe. If your lawn is wet and it's cloudy, but the sprinklers are on a timer, it didn't necessarily rain. Yeah, I mean, like if, in order for you to believe something beyond a reasonable doubt, that means that there is no other reasonable explanation. And if there is even one other reasonable explanation, whether they told you it or you came up with it on your own or whatever, if there's one other reasonable explanation, you can't convict. That's not the way it works. Do you think they might have discussed getting rid of Jennifer and he carried it out, then wrote the lies and alibi? I mean, it's definitely possible. Why would she manipulate the phone when he is gone and not freaking out because he is gone and his phone was there if she was so jealous? That's what makes me think she knew what was going to happen. Okay. That is part of what makes me think she knew what was going to happen too. But again, that's speculation on human behavior. So, because I would be like, why is his phone here and he's not here, whatever. Is it totally unreasonable that he would have left his phone? We don't know that. I've left my phone before. I very rarely leave it. It's very rare, but it happens. It's not proof beyond a reasonable doubt. It's something that makes me believe it, but I believe it like if this were a civil case and it just had to be like, it is more likely than not that she knew and conspired, yeah, guilty. Not even a doubt. But beyond a reasonable doubt is a heavy burden. They've heard the phone call was set up the night before. Yes, Fotis set up the phone call with Andreas the night before it happened. Yes. And Michelle made sure she was there to pick up the phone, which she did while the murder was happening. But see, I agree. However, I could also see, if Kent is in the office at that time and she goes up there to, what'd she say? What was her story? I don't think any of us believed her story, but what was her story? The stuff she went to print something out to return clothes for Nicole or something. So if she was up there and she saw Kent and she's, like, oh, hey, and sitting there talking to him and whatever and answer the phone. Well, they said that she answered it because she thought it was a girl or something. I don't believe it, but could it be considered reasonable doubt? She acted in furtherance of the conspiracy, but furtherance of the conspiracy, like all of the other charges have everything to do with hindering, prosecute or hindering investigation and disposing of evidence and doing all of these things. All of that has been proved. But the conspiracy to commit the murder is the biggest question here for me. I think she knew ahead of time, and I agree with Brandi, there's no smoking gun. Yeah. The evidence proven in interviews was that she knew because, okay, she lied about the morning of the murder. She wasn't banging on the shower because Fotis wasn't even there. Yeah, again, she lied constantly. But that does not necessarily, her lying after the fact doesn't prove that she knew beforehand. They're going to have the charge conference on Monday Monday, because they said defense is planning on resting Monday. So they're going to have the charge conference on Monday. So that will be interesting to hear exactly how they're specifying those parts, all of that stuff. Because there's not a lesser charge for conspiracy to commit murder. You either conspired to murder somebody or you didn't. There's no like conspiracy for, manslaughter. Like that's not a thing. So, I mean, if it is, I've never in my life heard of it, but you either conspired to commit murder or you didn't. All of the other stuff is all after the fact stuff, and all of that is, like open and shut, in my opinion. But it'll be interesting to hear exactly when they go through the charging conference what they talk about and what they want to allow. Innocent until proven guilty. Proven is the big thing. Proven beyond a reasonable doubt. Look, I'm saying I think she knew. But I don't necessarily believe it was proven. Is she going to testify? I doubt it. Because then she would have to get up there and answer for all of her lies. And she already talked so much in those 3 interviews. I don't think they want her to say anything. All of that suspicious behavior from Fotis combined with her strong personality is beyond a reasonable doubt. See, and this is... It might be a hung jury. Because I'm actually kind of surprised that so many people think that the state proved their case, because I don't at all. Not beyond a reasonable doubt. Beyond a reasonable doubt is a heavy burden. But one of the mods said this earlier. I think that, a lot of times people won't, there's a lot of juries that will convict based on what they think or believe as opposed to what was proven in court. But that also does lead to a lot of wrongful convictions. Conspiracy to commit murder, tampering with evidence, and hindering prosecution. So the tampering with evidence and hindering prosecution are the one that I'm like, yeah, like open and shut. Like not even a question. I love you just saying it. I almost 100% agree with you most of the time. Yeah, we're not always going to all agree with each other, and that's good. But also, I don't want to be one of those channels that's like, everybody's guilty all the time. Justice is not justice if it's not done right. So, no matter what I think, based on what we've heard, if it hasn't proven beyond a reasonable doubt, then, then there's still that chance that, that think about it like this. Think about what if think about it, it's not Michelle. Put somebody that you love in that position, and she's sitting there telling you, I didn't do it, I didn't do it. Somebody that you love, care about, trust, your sister, your mama, your daughter. Put her in that seat and look at the evidence from that way. Would you still think, did the state prove their case? If it was your sister or your mom or your daughter and you listened to that evidence, would you have heard that evidence and be like, my daughter knew ahead of time. She knew what was going to happen. She conspired to kill her. She knew what was going to happen. Or would you say, they didn't prove it. She didn't know. All this happened afterwards, and she was scared, and she lied about things because he was telling her something, but she didn't know. She would never have done that. If it was somebody in your family, would you still believe that the state proved their case? Okay, obviously you wouldn't be on the jury. That's not the point of that question. That's not inserting emotions, and let me tell you why. It should always be that strong of a burden of proof. You are supposed to assume that somebody is innocent until it is proven to you that they are not. And you cannot just look at somebody who you already know is lying about other stuff, and I won't say you can't. It's really hard to look at somebody who you already know is lying about other stuff, who you already think is a, crap person because she was having an affair with, a dude with 5 kids and then moved into the house. Like, she already has a lot of stuff working against her, so I'm not going to trust anything she says anyway. But we are supposed to look at somebody who is on trial as innocent until proven guilty. And the best way that I have been able to give that example is to picture it as somebody that you are super close to, that you love and trust. And think about what it would take, the evidence it would take for people to, whoever, to show you, to prove to you that this person that you love and trust, who you just know in your heart is innocent, how much would it take for them to prove to you that they're not innocent? That's the burden of proof we should be having. And it should be like that in every trial. Because that's what justice is. It isn't just, let's get a conviction. Yes, because of everything she did to cover it up, she had to believe murder was okay. Sandy Harp, I disagree. Those are two very different things. You agreeing with, or, going along with one crime does not automatically mean that you're okay with another. All right, I'm going to do one more poll before we finish. I'm really surprised that many people are so convinced, because like I said, I believe she did it, but I just don't think that the state proved it. If you were on the jury, what would your vote be for conspiracy to commit murder? I agree with you. The state didn't prove it, but I still think jury will find her guilty. Which is sad, really, because, like, not sad for her, but sad because it kind of goes with what we were saying about, you know, like, that's why there's so many wrongful convictions, because people do, I think a lot of times juries will vote on what they think or what they feel as opposed to what was proven. Why he used Jennifer's last name. Any other person in similar circumstances with a significant other would just use first name. If you're a couple, no need for last name. Why do you use Jennifer's last name for what? She knew something. What was she burning in that home by herself? Again, that's after the fact. You say she's looking from emotion, but most of you are speculating. You need to rely on evidence, and in this case, conspiracy evidence just isn't there. Yeah. I agree on that, unfortunately. Imagine the day after you find out your partner is capable of murdering the mother of children, how frightened you would be of him. Yeah, I mean, that would be scary. Will the state have a closing? Yes, they will do closings on Tuesday. Pavey says, I agree. I don't think the state proved conspiracy. I think there was one, to be perfectly clear. I just unfortunately don't think there was enough evidence of the conspiracy to commit the murder to be beyond the burden of reasonable doubt. I think she knew before, but I don't think the state proved she knew in advance. I think she did too. But you're right. I think she believed that the children would never love and trust her as long as their mother was alive. It would be hard for those kids to love and trust her. I mean, for them to, you know, Susie Homewrecker over there coming in, you know. Chunk of bacon. A friend of mine drove her brother home from a murder. And found out after. And she was found guilty of conspiracy to commit murder and given the hard 40 in Kansas. Jeez. That's crazy. Legally, I don't think the state has made their case in this trial. However, there's a lot of strong emotions with it that could tip the scales and get her convicted. Wrong legally, appeal then. Solo says, good outlook, Brandi, and sometimes we got to play devil's advocate and really see things from both sides. Yeah, that's all I want. I want to try to have everybody thinking about this from, you know, what if she didn't know beforehand? Do I think she did? Yeah. Do I think there's still a chance she didn't? Yeah. All right, I'm about to end the poll. We'll be done for the day. So it seems like, so the phone call, her answering the phone call that morning is the main thing that some of y'all are saying is what is the proof. Under your theory on not proven here, you would have to say Alex Murdaugh is not guilty. No, not at all. It's not the same at all. His defense brought up much reasonable doubt, but for his lies, no. It's, to me, no, not the same thing at all. If you add up all of the timeline stuff on his and all of the things that they were able to rule out, that was the biggest thing on his, is what they were able to rule out. Like that, you know, such a tight time frame, and we know that he was at the kennel, and then all of a sudden he hauled ass to his mom's house and all that stuff. It's not the same at all, because the other explanation for that would be completely unreasonable. There is another explanation for this one that is not unreasonable. So it's not the same at all. It might be hung. I don't know if I could vote conspire, or can I assume she might have known? I don't know. I think she knew afterwards, but I don't know before. Yeah. I think she 100% for a fact knew afterwards. I believe she also knew before. But see, from the before, I'm only probably 75, 80%. And that's not enough to convict, unfortunately. I won't say unfortunately, but it's not going to be a quick verdict, all guilty, and or it's going to be mixed bag verdict, hung one count, guilt on others. I think that the two after the fact ones are going to be like bam. But I mean, look at our poll right now. 63% say the state, say that if you were on the jury, you would vote guilty, and 37% say not guilty. So if our poll is split like this, then theirs might be too. This discussion is eye-opening. We're all practically professional jurors. Yes. So if we're torn, the non-professional jurors may not be able to separate emotions and instincts. That's true. It's true. The amount of discussion we've had here is definitely going to be similar to what the real jury is going through. I know, that's why I love this. I think it's so interesting. And I love hearing all the different perspectives, especially because I love that we can all disagree on all these different things and not be jerks to each other. Whose male DNA was on Jennifer's bloody clothes? Why aren't the police looking for them? Instead, they decide to go after Michelle. That doesn't make sense to me. The male DNA is not a huge deal to me because it was such a small contribution to those, and also it was in, in the trash bags. I mean, that could have been anybody. Like if anybody who folded her clothes, or like, to me that wasn't. What are you doing? What are you into? Get over here, bad dog. Anyway, sorry. That was, it wasn't enough on there for it to be, suspicious to me. Yeah, they had the video of the one guy digging through trash cans in the trash bag. I think, didn't he get a knife or something out of it? Or what was it he got out of it? I don't remember. Everything's running together. What are you whining for? But she answered the phone, and the person on the other end and knew it was her, so that argument doesn't make sense. She answered the phone, and the person on the other end knew it was her, so for the alibi phone call. The cleanup, wasn't there a female shoe print in Jennifer's garage? There was a shoe print. I don't know that it was female. I don't think that it was ever specified as female, but there was a shoe print. Oh, why did he use Michelle's last name in his letter? I don't know. He's an idiot. Ugh. Ugh. This is a great conversation and very eye-opening discussing it all. I have never been on jury duty and actually would love to do it now. I know they would never let me on jury duty. I'd be like, look, I'm a professional juror. Let me be the foreman. Let me make some charts. All right. I think I'm caught up. Yeah, he didn't tell them to leave Pavel alone. But also, I don't think they were messing with Pavel. Because Pavel was like, was like, hey, those aren't the seats that were in there. Like, he was offering information because he thought, something was fishy. So, all right. So let's end the poll. So 63% of you say that if you were a juror, you would vote guilty for the conspiracy to commit murder. And 36% say that you would not be able to vote guilty for that. So, I think the majority of us believe she knew beforehand. But I think while 36% of us may not be able to vote guilty, I think it is way less than 36% of us that actually believe that she didn't know. I do believe she knew. I just don't believe that there was enough evidence to prove it, unfortunately. But we'll see what the jury says. That'll be interesting. Charge conference will be interesting on Monday, too. Oh, and we have the contempt hearing Monday. Monday's going to be spicy. Spicy. All right, y'all. That's all we got for today. I am going to... What are you whining about? You want to say bye to your friends? Come here. Come here. Say bye to your friends. Say bye. Say bye. We're going to go watch the sunset. You want to go watch the sunset with me? She's so stinking cute. She's a bad dog. We'll probably be here about the same time tomorrow. Maybe about 11:30ish. 11:30ish tomorrow. And we'll do the same thing tomorrow that we did today. I'll put the little, if they don't come back with a verdict in the morning. That's 11:30 my time, Central. But we'll do the verdict watch too in the corner so we know when the Adam Montgomery verdict comes in, if it hasn't come in by the time we start tomorrow. So, alrighty, y'all. I appreciate it. Thank you so much. Mods, thank you. Y'all are the best. Darn, I have jury duty Monday. No, Lynette, this is your jury duty Monday. You have to be here Monday. Tell the other jury they're not as important as 13 jurors. All right, y'all. I will see you on tomorrow. Tomorrow's Friday Eve. I'll see y'all then. Bye.
Yeah, I gotta go. I can't stick around forever.
It was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel.
Goodbye, people. Now, how the heck do I get out of here?